Just before starting, good evening, Arya. I'm just waiting like a couple of more folks to join and then we'll start. Okay, so hope you had a nice weekend. Good evening, Apurva. So before we, start the class and let's wait for a couple of minutes, let's try to revise what we did in the last class. So I hope my screen is visible to you. My voice is audible. I am visible to you guys. So I hope everything is working fine. So can we start? I'm just trying to, revise. Okay, all good? Yes, okay. Thanks to confirm, Maria and Uma. So let's start. So in the last class, we started with the introduction of the corporate and business law. We discussed a couple of points about the exam, about the study sources you could use, about the technical articles, about the CBE's practice platform, which may not be as relevant in this exam per se. We also discussed the exam pattern. We also discussed study hub portal, which you could use, your ACCA my login, which you will be using, your workbook, and basically these notes that I will be sharing with you. So that is what we discussed in the last class, and then we went on discussing with the syllabus, like what would be the content. Right now we are currently discussing essential element of the legal system, like what legal system basically constitutes. And then we'll be discussing about the international business transactions, transportation and payment international businesses. So what we have started is with the essential element, and then we'll start discussing little by little about the international business transaction, about private law, international law, and then it will be all about the United Nations convention, treaties. I will be discussing model laws. Okay, all this stuff, and then basically we will use them in this piece, the transportation and payment of international business. This subject is about corporate and business law for the global. So here majorly we will be covering the international business, how international business transactions basically takes place, and this transportation and payment of international business, and the arbitral process will be a key significant component. So overall in this syllabus we will be covering the export import, the transactions that happen between two countries for the trade, and basically how dispute, how settlements basically happens, and what is the jurisdiction, or basically what is the source of law in that case, in case of different jurisdictions, different countries per se. So that we will discuss in the first half, and then rest of the half will be discussions around how what is partnership, what is companies, how companies are formed, how partnerships are formed, what is individual entity. And then basically we will then further uncover the companies there, how they bring the finances, capital, borrowings. What if the company gets insolvent or bankrupt, how we take all these cases. What are these terms? If you don't know, no worries, we'll be covering them in the upcoming sessions. So this was the overall broad line about the corporate and business law, and then we started with our chapter number 1, essential element of legal systems. So this was the index, and today we'll be finishing this chapter hopefully, and then we'll start the chapter number 2. If not today, by tomorrow, chapter number 2 and chapter number 3. Chapter number 2 is very small chapter. So in this chapter, what we started about the essential element, we first, I just touched you about common law, civil law, and Sharia law, and these will be the discussion point for today's class. Like, what is the common law? In the last class, I just give you a hint that common law is something that is based on the court decision, which is basically called judicial-based decisions. So common law is a phenomena that has been derived in the England, and from there it was exported to the entire world. So we'll discuss that in detail. What is civil law? Why I have mentioned France, Germany, India there. So we'll also discuss that. And what is Sharia law? So Sharia law basically is a law based on the Islam religion. Civil law is basically the law that have been codified. When I say codified, it means written. Okay, so these things we'll be discussing. I just touched them in the last class and did not discuss them in detail. The purpose was because it was going to come in detail in the later part. Then we went on discussing, okay, before we start thinking about what is, what kind of legal system we have, what is a legal system and what kind of system we have in legal. So first we understand basically how legal systems are derived. So for that we first understood what is economy system. Planned, market, mixed. Planned economy, basically government control, less private owned wealth. Market economy is basically driven by the market based on demand and supply, and less government influence. And mixed economy would be basically mixture of both. Now a mixed economy can be more towards planned economy, more towards market economy, based on the type of political system, like what political system that country has, whether it has a democratic system, whether it has a autocratic, or let's say basically dictatorship system. A democratic system is basically by the people for the people. Okay. And for autocratic, or let's say basically dictatorship system, is by one by a dictator or a ruler who will be governing the system. And based on their understanding, based on this understanding of economic and political system, we understood that legal system will form. If let's say we talk about a dictator, if they control the resources of the country, so accordingly they would develop the economy system. Let's say most likely it's going to be a planned economy. And in case of a planned economy, legal system will be supporting that system, like how the country will be shut from the rest of the world, how the trading will be happening at agreed prices by the government. There will not be any demand and supply. And these accordingly the civil law and the criminal law will be derived out of it. Okay. And let's say if it's a democratic country, so democratic political system where people choose their own leaders. So in this case economy most likely to be a market economy or a mixed based economy, because in current reality we have governments that run based on mixed economy, because government try to serve the purpose for public as well. Like they try to take certain sectors like healthcare, defense, which they try to support for the public. Okay. They, in order for the security and in order for providing the best services to the public, for the well-being of the public per se, they take these under their control, and rest is basically with the market, like private players, especially with the consumer items, with the pharma, or let's say with technology. These are all with the private items. So here accordingly legal system is right based on this understanding. Let's say the people are people have liberty to open their businesses, to do businesses that whatever they feel are okay with them, and they can do the businesses any places in the country. So this is the freedom they have, and there's no such restrictions on them. And that basically designs the legal system. So far so good, I hope so. And then we went on discussing about the legal system. Like once we have understood the political and economical systems, then we basically discussed about the legal system, like how legal system helps running the society, how basically law is there, basically which is a kind of body of rules which people follow in order to make society run. We discussed this thing like even in a democratic situation the people have to follow rules. So even in democratic countries people have to follow rules. The difference between the dictatorship and democracy is that personal basically private or personal life, the free will to live how you want to live your private life. Okay. In public places you have to follow certain rules, that you are not going to steal from somebody, you are not going to misbehave with someone. Okay. You're not going to damage public property. So even in democratic country you have to follow rules. The difference between democracy and the autocracy is that in democracy you have free choice of personal life, that you can exercise your fundamental rights, right of speech, and right of living. These are your fundamental rights. Right to vote, these are your fundamental rights which are given in the democratic country. Okay. In the legal system we discuss about the source or basically elements, country's law, the constitution, legislature, which I discussed in brief about what is legislature, what is executive, and what is judiciary. Legislature is the law making body, judiciary is the court. And in the judiciary, prosecution system is basically the system that helps punish the criminals in the criminal case. Like we went on discussing the legislature system, executive system, and the judiciary system. Legislature system is basically a body that creates the law. In case of India, it's parliament. Executive can be, represented by the ministers. Let's say parliament makes the law in India, and then this is, executed by the ministers of the country, by the IAS officers, by the police, by the administrators. So they are the executive. Here, for the example, we would be using ministers as an example for executive. Executive includes ministers, police officers, administrators, those who operate the law. Judiciary, we know that this is basically court that, interprets the law, and basically, based on the interpretation of the law, make decisions. And based on this judiciary, we will further define what is common law and civil law. That will be discussed later. But in the last class, we also discussed that there is a fourth pillar, media news, though it's not a part of your syllabus. I was just giving you an introduction. Let's say if you read newspapers, you hear news is, so you need to know like what this fourth pillar means, because this is a very general terms that are discussed whenever there is a political debate or there is a, any discussion on the news channels. Okay. And then we went on, after understanding the legal system, their elements about legislature, executive, judiciary, the constitution, the police, the prison system. Then we went on discussing the law in two terms: international law and national law. National law is basically, I hope that is easy to understand, is basically that is regulating a particular country. And in the last class, we discussed that there is no such thing as international law per se. Let's say there is no super government that is existing, that is, governing all the governments. Though governments come together, and they agree on certain way how they will, interact with each other. Like United Nation is one of the good example, which we will discuss later in the next chapter. Like what is United Nations and what is their purpose, why, how do they, conduct their business. So we will discuss that in the next chapter. But international law, like we were discussing, like I was giving example of Ukraine Russia war, like how, Russia has, violated the international treaties, how they have, invaded the Ukraine country. But in spite of that, they were they were doing that in spite of, violating all that treaties, all that, international laws. Why? Because they were a sovereign state. I hope you remember this word. Sovereign state means is an independent country, that they are free to do what they want. Though I told you that there is a repercussion to, violate the international treaties, violate the, international rules. Definitely the other countries are going to, withdraw from doing business from you, and you are going to suffer from that. But that is a repercussion. Okay. So there is no as such law that, governs the entire country. There is no as such particular super government. That was the intention I wanted to tell you. So when we talk about international law, basically is how we, deal with the other countries. Basically, different states, different countries basically deal with each other. And common examples for international law is like acquisition of territory, formation and recognition of state, and basically war, law, sea and space, treaties, treatment of aliens, human rights. All these are part of the international laws, and that have been discussed and, agreed by the countries in the United Nations, though we will discuss them further. Okay. And one of the example I was giving, like this is for, normal things, but one commercial example I gave. Let's say two countries where Mr. Harry and Mr. Ram is from India, Mr. Harry is from UK, and they are basically participating in a sale. So as per UK's law, Mr. Harry, if they have communicated early, so they have entered into the contract. And as per the law of Mr. Ram in India, that the contract will only be formed if it is in written. So if we see that two countries have two different sets of law, okay, now if these two parties contract with each other and then there is a dispute, which country's law will prevail? And this is what this chapter is all about. Basically, this is what this half of the syllabus is all about of this basically book, where we will be learning how parties with different jurisdiction actually, interact with each other, and which law is basically ultimately become applicable. Because so far we have established that international law as such, there is no such binding rule on any country. So how we will deal with that situation? Okay. And This was basically how United Nations has come and created the various convention treaties and international customs. So this is what we have discussed. Unilateral ozone layer, yeah. Okay, we'll discuss them later. And then we went on discussing like type of law in a particular country. There are normally two set of categories of law: criminal law, which is basically how, if let's say somebody breaks the law, somebody violates the law, let's say stealing, let's say murder, let's say committing a crime, which is let's say breaking traffic lights. These are all part of criminal laws. So there are repercussions. So in this case, if you anyhow you violate the law, which as per the state, as per the country, is basically crime, so you will be punished and government will be fighting against you. So in this case, the case is basically, in case of UK, it's called Regina versus the person. So here the Regina is the queen at that time. In case of India, it would be the state versus the person. Let's say state versus Jolly LB. I'm not sure like how many of you have seen this movie. So here that was a state case where state was fighting against the person. Okay. And there is a prosecution. Prosecution is the party that prosecution would be the person who would be responsible to make guilty, basically punished for their crime. So let's say if there is a prosecution, so they will file the case against the guilty, and then they will be trying to prove that the person is actually guilty and they should be jailed. And in this case, the guilty will be called defendant, and prosecution would be the person, would be the advocate or lawyer that is fighting to punish the person. And the burden of proof here would be beyond reasonable. So these are certain things that you must remember, so that in case a 2 marks question comes, so you can revise that. And I was discussing the Johnny Depp versus Amber Heard case, like, because we were discussing the civil law. So here I told you, like, Johnny Depp versus Amber Heard was a classical case of civil law where two party had dispute with each other. There was no crime. If that had been a crime, then the case would have been called as state versus Johnny Depp. Otherwise, this is currently called as Johnny Depp versus Amber Heard because of civil law. Here, there would be a claimant, and the burden of proof would be on the claimant. Okay, like the case was filed by Mr. Johnny Depp, so the burden of proof was on him. And in this case, the evidence that was required was basically balance of probability, like circumstantial evidences basically suggest that he's actually right or not. Where in this case, criminal law, the evidences should be basically beyond reasonable doubt. Okay, so this is what we discussed in the last class. So far, any questions? I just thought of revising the, because it was the last class was in the last week, so I thought first let's revise and then we'll start. So I hope till now everything is clear. Any doubt so far? Any questions? All clear? Good. So let's start today's class. So here we will start with this legal system, like the bodies. Let me know if you can see the screen. Yeah, this legal system. So I hope this legal system, legislature, executive, and judiciary. So in any legal system, so far we have understood that there are majorly three bodies, three pillars per se. Legislature, basically the lawmaking body that basically constitutes the law, constitute or basically make the law. This is some technical words that come out of my mouth, so I try to rephrase for you. Like constitute basically means creating. Executive are basically, let's say, ministers who run the law. Okay, let's say parliament has created any law, any famous law recently created by parliament. Like farmers act could not be passed. Any law, like anyone remember, like the famous recently there have been certain changes in the law, like, yeah, a reservation for women. This has been very recent. Like now parliament would have at least 50% reservation, or let's say 30% reservation seats for the article 370. Yeah, again, that is actually abolishment of a law actually. So there was already a law, so this was actually abolished. So right now I'm taking a women reservation example. So in India, we recently have a women reservation law that was passed in the legislature, basically the parliament. And this was, the responsibility of the ministers that this law is basically executed. And not only ministers, the let's say if it is a reservation, let's say at a school level, or let's say at any office level. Okay, so in this case, the not only ministers but also the administration of the government would be also be equally responsible. So I hope you understand what is executive stands for. Here we are using the executives, but definitely executives are basically a broader term, not only ministers. And these executives are headed by a elected leader, which we'll discuss. I'll just discuss the three cases for you: US, UK, and India. Okay, so let's read them. And judiciary is basically the court. So let's read them one by one, and then we'll basically discuss the cases. Okay. A branch of government, basically legislature is basically a branch of government responsible for making law with members elected by the public. Okay, so definitely we are right now talking about a democratic country, and it makes sense because legislature cannot exist in a dictatorship, because dictator will not have a legislation is where you make the law, agree, disagree, you debate. So in case of dictator, it would not be possible. So that's why it's always in a place where there's a democracy. So representative propose, debate, and pass law, ensuring representation and checks executive branch. So Parliament of India, US Congress, and UK Parliament. So in India we have Parliament, UK have Parliament. In US it's called Congress. Okay, US Congress. Elective executive. The executive branch, basically this is, let's say we talk about a government. So government have multiple branches. So legislature, the executive, and the judiciary. Okay, this is basically the part of the legal system. So this executive branch is basically headed by a elected leader. It could be president or prime minister. So we'll discuss like why there is a president, why there is a prime minister. Like I hope you understand that in US, president is a most strong, powerful entity, and in India and UK, the prime minister is a powerful entity. Can anyone explain me why? If anyone knows, we'll be discussing this. Anyone knows? Don't worry. The executive is accountable to legislature and indirectly to the electorate, basically the public. Okay. Examples, basically Prime Minister of India, US President, UK Prime Minister. No worries. That's what we'll discuss. Judiciary is basically a body, okay, a separate body, and most of the time judiciary is always independent. Okay, most of the time judiciary is always independent of these two. I'll discuss them how. Whether the government and the people, okay, if there is any dispute, a body that rules on any dispute basically decides. When it says rule, it means decide. A body that decides about any dispute between about law between a government and the people, like a criminal case, or between the people, that is civil case, responsible for interpreting laws, ensuring justice, and upholding the constitution. Okay. Supreme Court of India, US Supreme Court, or UK Supreme Court. And you would be surprised that each country has their own system. So let's discuss them. Like I'll be discussing like if you remember the purpose of having three separate units: legislature, the executive, and the judiciary, is for the purpose of separation of power, that no individual entity holds the entire government. Okay, so the purpose is for the purpose of separation of power. So we have three different law bodies, so that no individual body basically decides for whole country, so that everybody keeps on a check on each other, because this is very problematic if one entity has the entire power and nobody is there to check on them. So they will be somewhat become dictator. So dictator, basically, if you read the history of Hitler, na, so how he became dictator, he basically, he was part of legislature. Hitler was part of legislature, but what he did, basically, he got a position where he was, in power to hire people. He was in position to hire people, like he hired most of the people in the executive and in the judicial. So there was no person to contradict him. And later on, when he became so powerful, so he basically disabandoned the legislature. The legislature was completely disbanded. So that's how Hitler came into the power. So the purpose of this system is to keep a check on each other. Okay, this is the main purpose. The separation of power is basically for this legal system. I hope this is clear. Okay, so now let's discuss the country by country cases. Clear now about separation of power? Everyone, please say yes or no. If you have any confusion, let me know. I am ready to, clear these doubts, because this is the early stage. So this will be foundational for you. Okay, thanks, Ashna. Okay, now next, let's take the example and understand these terms. So if we talk about executive, so like audit requirements, some sort of learning and techniques of writing, is that the same law? We have learned the keywords. See, Kamal, when we talk about law, you have to use the important legal words the way they are. Okay, you are free to explain them in the manner you would like, but that is something for the professional level. Right now, what you are at skill level, and in the skill level, all you need is to answer the paper in basically like MCQ based. Okay, here in the skill level, there is no writing for the law. In the professional level, definitely you would be required to represent the law in the language that is given there. You will be free to write in your own language, but you need to use the keywords, but that will be for professional level. Clear, Kamal? In the in this paper, you would not be required to write, you only need to use the MCQ. Okay, Kamal, is your query clear, or your query was different? Okay, okay, okay. Actually, in the last class, I discussed all this. I discussed all this. Don't worry, just watch the last lecture. I hope this was already uploaded, so you can just watch it. Okay. So, executive. So in India, we have basically president as a ceremonial head. So executive will have a head. Executive will have a head as a state. But in India, we have president as ceremonial state, and prime minister will be the head of the government. So we do have a president in our country, but that is for the ceremonial purpose, not for any as such activity. Basically, they have certain powers over the military and over certain things, but that again require approval of the prime minister. Okay, so president is somewhat of a a ceremonial kind of position in our country, and prime minister is somewhat basically the head of the government. President is basically elected by electorate college. Basically, this is decided among the ministers. Okay, among the ministers by themselves. Whereas prime minister will be a member of parliament. Okay, in India, if I talk about India, he will have to first of all contest in their constituency, and then basically once they elected, after once they all the MPs get elected, the person who would be getting majority of the vote would be basically become the prime minister. Basically, the ministers among themselves basically deciding who would be their leader. But even the prime minister had to contest for basically getting elected. So this is the system that basically runs in India. Prime minister is the leader of the majority party, which is basically Lok Sabha, the lower house. Okay, we'll discuss what is Lok Sabha, Rajya Sabha here, but I hope this much is clear that president is basically ceremonial, prime minister is the head of the government in India. Okay, okay. Legislature. Legislature, basically India has two houses. When we talk about legislature, India has parliament and they have two houses: Lok Sabha, which is also called the House of People, or lower house, and Rajya Sabha, Council of State. Basically it is also called upper house. So if a law needs to be passed, how it will happen? First of all, it needs to be passed in the Lok Sabha. Okay, so Lok Sabha majority needs to pass this, and once it is passed in the Lok Sabha, then it will go to Rajya Sabha. So basically, once it is passed in the Rajya Sabha, only then the law will basically enacted over the country. Okay, what is the reason? Basically, very simple. Like we have discussed earlier, like we want to keep a separation check. How? Lok Sabha basically represent the central government in India. Basically, the entire country votes and basically elect the central government. In the Rajya Sabha, the country has been divided among different states. Like we have Delhi, we have Mumbai, oh sorry, Maharashtra, we have Rajasthan, we have Uttar Pradesh. So these are different states in India, like approximately 29 states and somewhat 7 to 8 union territories. I don't recall the exact number, but anyone can correct me here. Okay, so we had somewhat this much these states and 7 union territories, if I'm not wrong. Okay, so this basically this Rajya Sabha, how their members get elected. So like whichever government basically wins in these 29 states, their representative basically become the member of the Rajya Sabha. Rajya Sabha basically members get elected at the center level, 7 union territories. Okay, thanks, Arya. Okay, so Rajya Sabha member gets basically elected for basically, let's say you have a state in Maharashtra, you have a government in Maharashtra. So one of your representatives from the Maharashtra would be, part of the Rajya Sabha. So those basically the government that basically gets elected at local Rajya Sabha level will basically be part of the Rajya Sabha. Okay, so Rajya Sabha members are selected, and why? The purpose is, let's say a party that gets elected at the central level, the party that gets elected at central level, what if they start making some, absurd laws that are not favorable for people? So in that case, a Rajya Sabha has been, made, especially for a state like India, especially for a country like India. It is very much needed. Why? Because we have every state actually represents a different culture. Every states have different issues. So each state should have a say. It's not like only 2 to 3 states should have over dominance over the entire country. So that is the reason that there is a separate houses, Lok Sabha and Rajya Sabha, and that's why how the people are elected there are basically different. Okay, so this is basically legislature, and in order to basically make any act legal, first of all it has to be passed in the Lok Sabha, then Rajya Sabha, and then there is a process that president signs this act, but that becomes basically a ceremonial activity. So once a law is passed in the Lok Sabha and Rajya Sabha, so it almost becomes a law. So then there is further process, but let's not discuss here. Okay, so we have discussed this legislature. And while members of Rajya Sabha, like Lok Sabha member, are directly elected means by people, by people, and where Rajya Sabha member are elected by state legislature. We have state assemblies, like we have assembly in Maharashtra government, we have Delhi government, we have I think basically Chennai government, Tamil Nadu government. So we have different states government. Okay, Himachal Pradesh government. So these are state legislature, and they basically appoint their member to be represented in the Rajya Sabha. Now, Parliament is responsible for making laws at the national level. Now, what is the part of judiciary? Okay, and please understand, there is a reason that we call Supreme Court supreme. There is a reason for this Supreme Court word. Okay, in India and also in US, this is actually possible that if a law passed by legislature, or let's say parliament, okay, it can be quashed, or let's say it can be basically withdrawn or rejected. So I should not say withdraw, I should say rejected by Supreme Court. Whatever law is passed at the parliament or basically the legislature in India or US, that can be quashed or rejected by the Supreme Court. So Supreme Court has the ultimate power that whether a law will be basically applicable in the country. And it has many examples in India, like in 1960 itself, and even in 2023. So in 1960 there was a banking act, which was the for the purpose of making privatization of bank, banning. Government wanted to ban the privatization of bank. So this act was actually quashed by the Supreme Court. Supreme Court actually quashed this act, basically saying that this is unconstitutional. And similarly in 2023 itself, the Indian government has tried to introduce a collegium system. Let's not discuss what is collegium system act, because that will be an entire different topic. But let's say this was an act which Supreme Court, on the ground that this was unconstitutional, had just deleted this act, which is said that this act is not applicable, this you cannot enact this act. How? Because legislature basically bring its power from constitution. The constitution gives the power to the legislature, to the executive, and to the judiciary. And in the constitution, the power to interpret the law is with the judiciary. The power to make the law is with the legislature. Those who will be making the law will be the legislature. The law making body is legislature. But the power to interpret the law is with the judiciary. And that's why government cannot pass an act which is beyond the constitution. If government try to basically pass a act which is beyond the constitution, so judiciary can eliminate or reject that act, and that act will not be applicable to the country. So this is the power that is basically no, as long as let me just clarify. I knew that this doubt would come. So Omar says that that means we need prior approval from the Supreme Court. So that means we need, not only in India, we need approval of the Supreme Court. No, that is not the case. Supreme Court has only power of interpreting the law. Interpreting the law. Okay. If parliament, or basically let's say legislature, parliament or legislature make any law that is within the bounds of constitution, okay, then Supreme Court cannot do anything. It can only interpret it. It cannot reject it, because if parliament has made any law which is within the constitution, then it is okay. But if any law that is controversial, that is basically is beyond the constitution, beyond contribution, in law we have a term which is called ultra virus. Beyond the constitution, then it's called ultra virus. Yep. Yep, Arya, I think you have read it already. So if this is ultra virus, then this cannot be enacted, because that it becomes unconstitutional. It becomes unconstitutional. So that's why only laws that are so complicated, or basically laws that go beyond constitution. Let's say, let me just tell you one act. Let's say if government start make an act, make an act that nobody can stand on two on basically on their both on feet. Nobody can stand on feet in public places. Okay, legislature basically make this law. Don't you find this law very absurd? Don't you find this law very absurd, that you cannot stand on your feet in public places? Is it not at the heights of absurdity? And it's basically against your fundamental law, against your fundamental rights, against your fundamental rights. So the constitution gives you fundamental rights. So any law that snatches away your fundamental rights will be basically ultra virus, and Supreme Court can directly come and delete this act. They would say they will reject this act, and they will not basically let the act enacted in the country. So is this clear? Okay, so this is basically what judiciary does. Okay, and one more thing. Okay, okay, that would we'll discuss in the interpretation of the judiciary. So we'll also discuss the role of judiciary in the interpretation. Now let's discuss the United States. United States, the only difference I see in the United States system and our system is that the power of president. The power is the head of executive branch. Basically, president is the head of executive branch and responsible for enforcing law. President is elected 4 year. In our case, is 5 year, though it's just for general knowledge, but I just wanted to know this, that these are the things. Okay, president is elected every 4 year in United States. In India it is elected every 5 year, and in India we have the prime minister. In US they have president, and that is the only difference I see in the United States system and the Indian system, though there is further layers, but I'm not, for this for the purpose of this class and for the purpose of syllabus, I'm not discussing those things. Okay, so they please understand, we both United States and India have a system. United States run on the federal system. In India we run, I think, on the I'm not recalling the term, but we run on the central. There's a scheme, basically, how this hack enacts. Let me just quickly tell you. This is just for the purpose of your knowledge. Like, United States have 15 states, and are free at any time, at any time, if they want to withdraw from the country. Okay, the United States is basically union of different states. United States. Okay, sorry. United States basically made of 50 states, and that's why it's called United States, USA, United States of America. Okay, so these 50 states have a free will to withdraw from the state anytime they want, and this can only be, this system is only suited for people which have high education. In India, and this is basically called a federal system. This is called federal system. In India we have 29 states somewhat. Okay, but in India we do not allow withdrawing from the state. Withdrawing, no state can withdraw itself from the country. Okay, and this is basically required where, mostly for the developing country nations, that they want, they, because most likely people can be influenced, and they can separate the state of a country. But this is the idea, is that we run on a union system. I think this is the word. I am not clearly 100% sure, but there is a federal system in US and we have a union system. Okay, so what I was discussing, that they have a federal, basically they have a presidential system, unitary system. Okay, 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 Kamal. Okay, okay. Yeah, I was not able to recall that. Okay, okay. Thank you. So India, we have parliament. Yeah, yeah, yeah. Federal system with unitary features. Okay, you guys are very known. So parliamentary system where prime minister has superpower, and this is basically adopted from the UK, adopted from the basically UK system. And US has basically the presidential system where they have president as the head, and they have 50 states, and that states basically make the United States. And we have India, which basically makes 29 states. Okay, now the legislature part is basically somewhat similar. This is called basically US Congress, and US Congress have basically two houses. One is basically called Senate, the house of, okay, Senate, and second is called House of Representative. Congress is responsible for making the federal law, basically the government laws. Okay, the senator and representative are elected by the people. Senators serve 6 year terms, and the representatives serve 2 year terms. These can vary. I'm not sure, I have picked this thing from the internet, so just for your information, but can be, this term period could be different. The purpose of the legislature is same, basically making the law. Okay, judiciary. Again, similar to India, we have the Supreme Court in the US. Okay, highest court in the India. Why highest court? Because there are set of courts like Tribunal Court, High Court, Supreme Court. We'll discuss them in later, and mostly we will discuss the UK court system. Okay, so Supreme Court interprets the Constitution and has the authority to review the constitutionality of the law. Basically, what I was saying earlier, that Supreme Court can quash any law if it feels that it is not constitutionally valid. Okay. Federal judges, including Supreme Court justices, are appointed for life by president with Senate approval. Okay. And finally, we have UK. UK has a prime minister, which is the head of state, similarly like India. Prime minister is the leader of political party there. Okay. With majority of House in Common. What is House in Common? Basically their legislative body. But there is a difference in United Kingdom, and there is a reason for that. That United Kingdom does not have a president. Did you know that? United Kingdom does not have a president. They do not have any president. Yep. Do you know what is called Kamal? You have correctly said they have queen. Now they have king. The queen after the queen. Now they have king. Like recently, I'm not sure like whether you have heard the news. Now the Queen Elizabeth has passed away, and this is King uh, King Charles. So they do not have the president. They have monarchy system. Monarch system. Monarchy. Basically, king and queen system. And this is actually what I understand, if I remember correctly, this is the oldest monarch system. What is monarch system? Monarch system where king or queen is the head of state. So even in India, we had a monarch system before the infiltration of the British Empire. So we had this monarch system where there used to be a king and queen who rules the basically all the lands. Okay, wherever they have the jurisdiction. So they used to rule the basically places. So because after the British Empire, the king and queen were overthrown, and then basically it was the British who was ruling the India, and then later on the government basically was formed. 1947 we got the independence in India, and then basically we did not switch back to monarch system. We basically switched to the democratic system. The people, the king and queen of that time, okay, this is not kind, this is king. This is king. So the king and queen at that time, basically, whatever power they had on their jurisdiction, they were disbanded, but they were given the right or privileges for their palace. Like if you know, in India, whatever palaces the king and queen have, they were given the right that you can own these palaces, you can continue to own these palaces. Like there's a famous saying in India, be the king of your own palace. And this is actually coming from that, be the king of your own palace. Okay, not of people. So the king and queen in India were given this option that you can be continue to be king, but only at your palace. Okay, you have no right over people. You have no right over any territory. You are given your palace, and you can enjoy living like that, but not more than that. But in United Kingdom, they have continued this monarch system. And just like presidential system, the king and queen as such have no power except ceremonial. This is again ceremonial. So king and queen as such does not pass any law, does not authorize or basically have any per se basically say in the lawmaking or basically any executive activity. That is done by the prime minister, that is done by the system, that the administration system, that the legislature and the executive system, that is done separately. But the purpose of king and queen there is to to ceremonize, to celebrate their culture. What I understand about it, because even if we will be learning about court system of UK, and we will learn that one division of high court is also called queen bench of division. Okay, so this is somehow embedded in their system. So they run the democratic system along with monarch system. So this is a unique feature of the United Kingdom. Okay. Monarch system, how this is, and you can say that if you compare the dictatorship, it used to be, the dictatorship was part of the monarch system. Kamal, prime minister is, let me just first of all take up this question, that who has the highest power, king or prime minister? It is prime minister in UK. Prime minister has the highest power. It is the head of the executive branch. The like in India, similarly, like in India we have president, but that is for ceremonial purposes. Similarly in UK we have king and queen, that is for ceremonial purposes. Clear, Kamal? Now, Afan, your query about monarch system, where what is the difference between monarch and dictatorship? I would not say different, I would say that in monarchy we have seen that dictatorship was part. Okay, dictatorship was somehow part of the monarchy. Why? Because kings and queen used to decide what would be the rule. Okay, but they had a proper system. They had a proper system. Like, they would define, okay, what would be the rights of the king, what would be the, rights of the people. They would, run the economy. They would, the system would actually basically were more balanced than clear dictatorship. Okay, monarch is basically, just think of in your mind that monarch is nothing but a system run by king and queen. Okay, now when you compare it with the dictatorship, dictatorship can be done by any individual or can be done by sometimes military. Okay, Afan. So the monarch system has been a historic thing. The dictatorship has been like somewhat 200 or 300 years old, but monarch system has been like thousands years old. Okay, Afan. And the thing is that people accepted this monarchy system. People were, used to this monarchy system. If you think about, people living in UK, they still, see their king and queen very respectfully. But if we talk about dictatorship, just think about the perception people have about a dictator. Like, they are always afraid of them, right? Now, in uk legislature uh, in uk legislature, the parliament basically consists of two houses. Similarly, like this is common system like in India, like in US, just the names are different: House of Commons and House of Lords. House of Common where basically people elect, and House of Lords is basically where, the lords are appointed. House of Common people elected, and House of Lords are appointed. Parliament is responsible for making and passing the law. The exception of the UK system is that if let's say a law is passed, if let's say a law is passed by the legislature, then Supreme Court cannot quash it. Supreme Court in the legislature in UK does not have the power basically to quash the laws of the legislature. If there is a mistake in the law, then that has to be corrected by the legislature itself. Supreme Court cannot, override any law. Clear? That is the exception of United Kingdom. Everyone clear? Okay. Okay, so this is for your self-reading. Like, this is something what we have discussed, like how US Constitution was designed, how separation of power is basically created, what UK has basically, and how they have unwritten constitution. That UK does not have a written constitution. They have somewhat we call unwritten constitution. Like, if we try to go, we can read the Constitution of India, but we don't have as such, UK constitution. And there is a very logical reason. India got independence in 1947, and India followed somewhat of a civil law and somewhat of a civil law. I will discuss just this civil law and common law. So India just followed the civil law where they have codified their laws. They codified their statutes. So in this codification, the Constitution of India was basically brought. But in UK, they basically, they were the colonial people, and they were, ruling over. They were following the imperialism. They were, just basically broadening their empire to other countries. So they never, need to free themselves, and they had this monarch system, and they had the one of the oldest monarch system in the history. So their monarchy was going on. So they never need to, written any particular constitution per se, but they have developed certain practices, certain customs, and certain, rules and regulations that have, been a general practice. So if you ask what would be the law in the UK, people would understand this. And that we will discuss that how this is a common law in the UK, and how India has a codified law, which is basically civil law, which we'll discuss. So please read them. This is a good read for you. I have intentionally given them for the self reading. you have already understood the concept, and once you read them, you'll basically get a good understanding. Okay, and this is basically discussing what is legislature per se for UK, giving in more details. Okay, executives, and finally the judiciary. Okay, so please read them. This will be a very interesting read for you. And now we will be basically moving to the common law and civil law, and then we'll basically also discuss the power of court. Okay, so please read them. This will be a good read, though I know many students will not, but I suggest you to go through this at least once. At least once. This will be good for your information. Okay. Now let's come back here. Legal system, separation of power. We have we have not discussed the common law and civil law. Okay. Okay. Let's discuss this. So what we are going to discuss is civil law and common law. So in these two, whatever they are for the timing, just think that whatever these laws are, the court exercise a limited control over the action of public bodies by a judicial way. Okay, what does it mean? Basically, the review usually take place at the instance of individual whose rights have been infringed by the public body and whose claim that public body acted either. Basically, this is ultra virus. Why this piece is here? Judicial review application, Queen Bench revision. This okay. Let's come back from Let's first read the common civil law and common law, and then let's come back here because I'm not sure why this slide is here. The slide should not be this early. Okay, no worries, because Queen Bench division part is here. Okay, okay, okay. Let's skip this slide. Let's skip this slide. We'll come back on this. We'll come back on this. Okay, let's start the common law discussion. Okay. Uh, I hope we are all okay. Any doubt? No confusion? I have intentionally skipped that slide because let's first understand the concept of common law and civil law and the court system. Clear, everyone? So far, so good now? Yes. Okay. Thank you, Kushi. So, common law. Like I mentioned earlier, common law is a system basically based on court decision making. Just a second, huh? Yep. So what we were discussing, common law. So common law is basically, how this common law actually came. This is basically originally originated in England. Basically, this is also sometimes known as English law. Okay. Why? The earlier system was, let's say, if two people have dispute, if two people got dispute, they used to go to the court. Okay, and in the court, one person would be listening to the both parties, and once they listen to the both party, they would decide, okay, which party is correct. Okay, case basically where the case should go. Okay, in whose favor the case should go, and who should be liable to. Let's say two people fight with each other, and in this case, what happened? Fight with each other, and what happens, let's say the person who are fighting, basically one person got bruised, one person got injuries, so they the person takes the other person to the court and basically says, okay, this person has physically hurt me. Okay, so court would decide what would be the course of action, and when court pass a law, once court pass a decision pass a decision, this would basically become a kind of this decision would be basically later on called a precedent or a kind of law. What is a precedent? Precedent is basically, let's say court decides something for a particular case, and if a similar situation occurs again in the future, so in this case the people don't have to go back to the court. The previous decision passed by the court would be considered as a precedent, okay, or a law, where they would know, okay, what would be the further course of action. Let's say If these two people fight with each other and one person was got bruised or basically injured, and then it was later discovered that because a person, for let's say it was Mr. A and Mr. B. So let's say if Mr. A attacked Mr. B, so in this case Mr. A should be sent to jail. So in future fights, let's say in case, let's say Mr. C fights with Mr. D, and here Mr. C attacks Mr. D, so here in this case Mr. C would be the culprit and this person should be going to the jail. Why? Because they don't need to go to court here. Here, it would be a established fact that the person who attacks would be the person considered as culprit. So this basically creates a precedent. So in the common law, the English law, basically, the idea was that whatever decision was derived from the court should serve as an act. Okay, basically creating precedents. Is this clear about the common law? That how common law was derived, what was the thinking behind the common law? Here, please understand, A and B both are fighting cases, and here court is basically listening to them. Okay, so court, what court does here, what court action would does here would basically define whether it's a common law or whether a civil law. Okay, in common law, if court basically is kind of a referee, is kind of a referee and listens to their situation individually, so here it would be most likely into the common law. But if this if the case is basically fought under the civil law, then here court would basically make kind of an investigation, okay, and would try to arrive at the truth. So here we are trying to find the facts, but in the common law, the question is not of a fact. Question is not of a fact. We are not discussing what is a fact. We are discussing what is basically who will be basically who will be punished and who will be rewarded. So in common law, the court basically serve as a referee, but in the civil law, the court worked as a investigator. And in this sense, I'm not sure like how many of you heard, the common law is also sometimes known as adversarial law. Adversarial law, your adversary, your adversarial, basically your basically companion or your basically not sometimes, the practice of common law is whatever court decision is, that will be the law, Kamal. Okay, let's say people are fighting, or let's say let's not talk about fight, let's talk about trade, because we are here to discuss the business cases. Let's say two people have trade, example of Mr. Kamal and Mr. Harry and Mr. Ram. Let's say they are in the same jurisdiction. Let's forget, like let's say both are in the same country, and let's say they both go to the court. Okay, so in this case, if court decides that how the contract will be formed, that will become the precedents. That will become the precedents. Okay, so court decisions becomes the law in case of common law. Okay, which is called precedents. Let's further understand it. Let's further understand it. This is just me and teaching you, or just me telling you, but let's further understand it. So key principle, what are the key principle of common law? That law do not become inoperative through lapse of time. Let's say if a decision has been passed in 1800s and we are following a common law system, then even in 2023, this law will still be applicable. It does not become inoperative through lapse of time. Good example would be, we have somewhat hybrid system, Uma. In India, we have hybrid system. We have constitution, which is basically written. Okay, and written means basically codified. If a law has been codified, then this is a civil law. But judiciary plays an important role. Whatever judgment judiciary passes basically becomes landmark judgment. Landmark judgment means they set precedents. They kind of become law. Okay, we'll discuss like how our system is more of a civil law and not more of a common law. In UK, it is more of a common law and not of a civil law. Okay, that we will discuss. New law developed by the legislature are presumed not to alter. Okay, presumed not to alter the existing laws. So in common law, when you create a law, okay, so that law is presumed to not contradict the law, but rather supplement it, rather further enhance this. Okay, judges apply the law and must apply decision reached in previous subject to certain conditions. That is, no material differences between the cases in question. The doctrine of judicial precedent, which is an important concept of in common law. What it means, let me tell you. If a court is basically, taking up a case and the material facts are same, already part of any previous judgment. So in this case, the court has to consider this, consider the precedent. Okay, the precedent. The purpose is, let's say, if court has a case between two people, okay, and what has happened, the material facts are same. So in this case, the court would basically, does not override previous decision. It would continue what was the previous decision. Let me give you an example. Let's say a lady, let's say a lady goes to a shopkeeper. Okay, okay, and in their shop, the lady got injured. How? Basically, the floor was wet. Floor was basically wet, was not properly cleaned. Okay, now what happens? This lady goes to the court and basically file case against this shopkeeper. Okay, and the court basically based on the evidences that shopkeeper did not take properly care of their premises, based on the negligence, court favors the lady and favors the lady and pass the judgment in favor of lady. So in this case, next time incidents happens, next time an incident happens where a person a person gets injured in a shop. So in this case, the court would use previous case as a precedence. Okay, previous course as a precedent, and they would not change this precedence. Okay, is this clear? Everyone clear? Mhm. Okay. Yes. Okay. Good. So, what are the sources of common law? Common law, basically the body of law, basically judiciary basically decides the cases, evolved through the application of doctrine of judicial precedence. So in order to common law to develop, it takes centuries, and that's why it's called English law. And that's why it's called English law, because this law was first introduced in the English system, and after 2 to 300 years we had this civil basically the civil law. Oh, no, civil law is later on. Okay. So this is basically formed after centuries, like people start taking decisions, the courts start taking decisions, and then basically this becomes into the picture. This is a concept, equity is a concept which was later introduced. This was later introduced in the common law. The purpose of equity system, that sometimes common law could become very rigid or complex. What does it mean? Let's say, let me think an example of equity where I can explain you. So let's say, mm, one person is trading goods. Okay, and as per a previous precedents, let's say the ownership. ownership of good transfers to buyer, okay, when delivery is complete. Okay, let's say, let's say, uh, shopkeeper, shopkeeper, let's say they have a sofa or furniture that basically, is delivered to the owner. Okay, but owner was not present at their home. Owner was absent from their home. So what shopkeeper would do, basically they would deliver the sofa then and there, and whether or not the owner, the buyer basically, takes the ownership there. Okay, the buyer does not take the delivery, but the shopkeeper, delivers the sofa there, whether or not that would be picked by somebody else. Okay, so here, as per the precedent, the ownership has been transferred to the buyer the moment the shopkeeper has delivered. But the intention of the law was not that. Okay, the intention of the law was that once the person who has bought the goods has actually received the goods in the good faith, right? But here the shopkeeper is, using the loophole of the precedent, that once the delivery is complete, only then will basically, will consider it as a complete delivery, and my responsibility will be completed. So here the concept of equity came. The concept of equity came, that says, okay, you cannot, misuse the law. Okay, just because a precedent is there, you should not, misuse the law on basically unfair grounds. Okay, so there should not be any unfair ground, that you say, okay, the person was not there but you still made the delivery, so that is counted as a completed delivery. Okay, so here the concept of equity was that it should not be unfair to anyone. Okay, the purpose of the law is to be fair to each party. So that's why the concept of equity was later on introduced, and this common law and equity law would later basically becomes case law. Okay, where basically we see the precedents that has happened and try to see whether material facts are, applicable to the case, and whether we would be applying the precedents. But the ultimate purpose is to see whether law is fair. Okay, that it does not lead to any unfair reasonable ground. Okay, so that's why this equity concept was later on brought. So when we talk about common law, so equity is also a concept. Okay, that at no point the law becomes absurd. Clear, everyone? Clear about the concept of equity, that how equity was brought? Okay, then basically you can also have the practice of common law. Basically the source of common law can also be the statute, basically the law that is made by the legislature, that basically makes the codification. But Vishal, we have discussed the codification will basically make the civil law. Basically, as I said, common law is, develop over the centuries. So let's say if there is a law and there is an ambiguity in interpreting the law, so in this case the statute will also be source of the common law. Delegated legislation, basically it means that basically parliament does not only make the law but also these cooperative bodies, but that we'll discuss later. That we'll discuss later. Sorry. Custom or historic law, what have been the custom? So what have been the practices? When I say custom, it means practices. The constitution in common law country that have a constitution, very, that is though very contradictory. Constitution normally, countries that follow the civil system has the constitution. European law in all countries that are also part of the European Union. We'll discuss the European Union when we'll be discussing the basically multinational organizations, like in chapter number 2. We'll discuss this there in chapter number 2 about the European Union. How many of you though know about the European Union? Is there anyone who knows about the European Union? What is European Union? Otherwise, I'll discuss. Okay, Arya, what is European Union? Can you give me a definition? Basically, explain them in simple terms. Or I'll discuss this in chapter number 2. Have heard. Recently, in Russia-Ukraine war, you might have heard about the European Union taking action. Germany, France, UK. Basically, UK has exited from the European Union. That is called Brexit. Anything? No worries. So when we talk about delegation legislation, so we'll discuss this in chapter number 2. Delegation legislation is basically where not only parliament but other authorities also make the law. So this is for yourself because this is dedicated for the UK, like how UK basically the law is enacted not only from the parliament but also from the other houses. Okay, now very important. So before we start this topic, should we take a 5 minutes break or is it fine we continue, or 10 minutes break? Tell me. Union has a different countries. Yeah, 10 minutes break. Okay, 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 okay. It's 3 hours, Kamal. It's 3 hours. Okay, 10 minutes break. Okay, okay, sure. So basically, Arya, to answer your question, European Union basically is, 28 countries coming together to form an alliance, and that is for the purpose of free market. But we'll discuss this in the next chapter. Okay, like what is the free market, why European Union was created, that we'll understand in the next chapter. Okay. So 10 minutes break, guys. Let's meet at 7:30. Okay. Now it's 27. Earlier it was 28. Like UK also was part of it. If you do the Google research, you may find it is currently 27 because of the Brexit, Britain exit from the European Union. It's a very interesting story. Any questions? Let me know. We are on 10 minutes break. Okay. Hello. Are we back? Yes. Okay. So let's start with the discussion of role of judges. Okay. What roles basically judges play in terms of common law? So when we say common law, the role of judges basically is very critical. Here, what they do, they apply the law consistently with the previous decision of judges, unless there are valid reasons for overruling previous decision, which is basically equity. Okay. Interpret the statutes made by the legislative, review the law to determine whether it conflicts with overriding principle of law, which is basically constitutionality. Constitutionality of law. For example, US Constitution. This is not a feature of the UK judicial role. So as I told you, that UK does not permit the Supreme Court to decide whether a law would be acceptable or not. Okay, that it is ultra virus or not. If a law is basically ultra virus, that UK Parliament or UK basically UK uh, legislature has to decide for themselves. So UK court and their hierarchy. Now let's discuss. Basically, we have discussed the that how judges will be basically making the law. And let me just bring the hierarchy for the court. This is actually in your BPP book. This is actually discussed in your chapter number 3, and there's a very good graph. So let me just draw that for you. So when we talk about the role of judges, they apply the law consistently with the previous judges, basically precedents, unless there is a equity concept. They interpret the law and they can also check the constitutionality of any law made by the legislature. But exception is for the UK government. Okay. Now, what we are going to discuss is how courts basically function. What is their hierarchy? So, any of you who wants to know, tell me like what is Supreme Court, what is High Court? Anyone who knows this? Voice is very low. Kamal says voice is very low. Is it for everyone? guys? No, nope. Kamal, actually, everyone is saying no, so please check at your end. I hope it's fine. Okay, so let's see. Basically, hierarchy. It's actually very good. Let's say, mm, see, the hierarchy will be discussed in two sense: criminal versus civil. And when I say civil, I hope you understand. Whenever term of civil will be used, it will be for the country law, okay, and not for the legal system. There is a civil law and common law. This basically defines the legal system. What is kind of legal system? Whether we follow the code-based system or we follow the constitution or law-making system. But when we talk about criminal law or civil law, this is different. Okay, this is different. This civil law is not similar to this civil law. In the last class, we discussed that any crime that is, punished by the state would be under the prosecution system. Okay, there would be, police, all that. In the civil law, that would be a dispute between two parties. Okay. Arya says Supreme Court is the highest case, where the higher court is the lower court to Supreme Court. So any court lower to the High Court, Arya. So this court hierarchy is given. Court hierarchy, in case any student is interested, is given in your BPP chapter number 3. Okay, we are discussing this here. Okay, tribunal courts. Okay, so let me just break it down for you, Arya, and for everyone else. District court, high court, Supreme Court. Now this is why I was interested in, because Arya has used tribunal courts and Afan has said the word district court. So this is why it's interesting to see, like, what is this categorization. Sometimes you hear this district court, sometimes you hear this tribunal court, sometimes it's actually, oh sorry, sometimes it's actually the magistrate court. And in UK system you would hear the word crown court, queen bench division, family court, chancery court. So these are the words. So let's first of all break this down. So first discuss the Supreme Court. So Supreme Court is basically common for both. Okay. In criminal case also, in criminal case or in civil case, we have the Supreme Court. Okay. Just guys, one minute, huh? Okay, so we have basically Supreme Court, which governs both the civil courts and criminal court cases. So Supreme Court would be, taking care of this. It's just that it will have two divisions. One would be taking care of the criminal cases, and one would be care for the civil law cases. Okay. Below the Supreme Court, as the Afan, Arya have mentioned that the lower court, the Supreme, is basically called High Court. Okay. Now in High Court, what will happen? High Court will basically have different categories of basically. I think Court of Appeal would also come, but let's take this Court of Appeal, High Court. Yep. And here, what would you have? Court of Crown. Okay. Court of Crown and Court of Appeal. Yep. Court of Appeal, Civil Division, Court of Appeal Division, and then we have High Court. Just a second, huh? Let me just cross check it. Supreme Court, High Court. Prevail House of Law is the highest applicable question. Any appeals from the court can only be considered in the European Union. Okay, got it. And then House of Lord, which was the highest court appellate tribunal. So Court of Appeal, second highest court in the UK. Two division criminals appeal. The civil division have country court and the High Court. Okay. Civil division, country court, and the High Court. Criminal division have the Crown Court. Okay. So in the UK, the second highest court. Oh, this is actually the second highest court is basically called is called is called let me just write it with different pen, is called court of appeal. Okay, this is the second highest court. First is the Supreme Court, second is the Court of Appeal. And Court of Appeal again have two branches, criminal division, and this is for the civil division. UK Court higher. Okay. So Court of Appeal will be the second highest court in the UK, where we would have, criminal division and civil division. Okay. So before going to Supreme Court, you have to first go through the Court of Appeal. And in civil division of basically Court of Appeal, before going to Court of Appeal, you have to go either from the High Court or Country Court. Let me just write. Because there is three divisions also, QBD, Queen Bench of Division, Family Division, and Chancery. And there is a Country Court. And in case of criminal code, what happens is here, Court of Appeal basically gets from the Crown Court, or Magistrate. Okay. See, this is how the order for the UK code-based system goes. Basically, what happens here? First, let's say if you have a criminal case, so what will happen? Where is the chat? If let's say you have a criminal case, so let me just write the criminal cases from the green pen. So if you have a criminal case, so first you will go to a magistrate court. Magistrate court, if the crime is not severe. If crime is severe, then you would go to a basically Crown Court. Okay, Crown Court. And based on this, you can then fight your case in the criminal division for the Court of Appeal. Okay, when you basically let's say the judgment gets passed and you want to fight further, so you would go to Court of Appeal in the criminal division. And let's say here you are not satisfied with the decision, then you can go to the criminal division of the Supreme Court in case of a criminal division. So first you go with the magistrate for the basically petty or not so big crimes, and you go to Crown Court for any severe crime. And then basically there is a criminal division of the Court of Appeal that you go. And if you are not satisfied with the Court of Appeal criminal division and result, then you can go to the Supreme Court. This is for the basically criminal court structure. If we talk about the if we talk about the if we talk about the civil division, so what would happen? You would first go to the Crown Court. This is Crown Court now. Okay, so not Crown Court. You would basically go to the civil cases, High Court, Country Court. Okay, county courts, first instance of civil court, and then High Court. Okay. So here, this second division also. This is County Court. County Court. So first thing you would do in case of any civil cases, not green pen. Yep. Pen let me use. So in case of any criminal any civil cases, what you would go, first of all, you will go to the county court. If you are not satisfied with the decision of county court, now depending on your case, you would be headed in the High Court a Queen Bench division, a family division, or a chancery division. What is family division? This is for matrimonial purposes. Let's say you have any husband wife issue, so you would go there. Okay, from county court. Queen Bench division basically serves, let me just quickly check. Queen Bench division deal mainly with contracts and tort disputes, and chancery division deal with law, trust, probe, copyright, company law. Okay. So in this civil code, let's say if you have any issue in the Companies Act, Partnership Act, okay, or any, any severe claim, so that would go with the chancery. But if this is basically a contract dispute, so you would go with the Queen Bench Division, and this would basically constitute as a High Court. But if you are not satisfied with the decision of the High Court, then you go to the Court of Appeal. Okay. And if you're not satisfied with the Court of Appeal, then finally you go to the Supreme Court. So this is the hierarchical order for the UK system. Okay. Is this clear? What trot means? Okay. First of all, tell me whether this piece is clear, that how civil court or criminal court cases are filed. Yes, that you first go to the county court, then Queen High Court, family or chancery, and if you're not satisfied, then basically you file the Court of Appeal and then Supreme Court. And similarly for Crown Court, Magistrate Court, you go to the Criminal Division and then basic Criminal Division or Court of Appeal and then Supreme Court. You would see the hierarchy in case of the Supreme Court for criminal is very less, but in case of a civil court, it's very high. The reason is for basically, once a dispute between two party needs to be settled and a Supreme Court decides a case, then this basically sets a precedence. So before coming to the precedent part, it has to be, thoroughly checked. It has to be, thoroughly checked and, very much ensured that this is, the final decision of the Supreme Court should be, should be carefully taken. So that's why this part you can see is very, longer in case of civil cases. But in criminal cases, because we just need to, prove the crime. Okay, so in this case it's most likely that the and in case of criminal crimes, the justice needs to be served, as soon as possible. So that's why the division here is very less as compared to civil division. So far so good. Just a second. Okay, please read this till the time. So far so good, guys. Just a second. Please hold. Yes. Okay. Supreme Court, House of Law. This was just for your FYI. Please don't need to remember anything. Okay. Court of Appeal, second highest court. Uh, Two division, criminal and appeal, and civil division. Court of Appeal before they can be heard in Supreme Court. Civil division before they can be heard from the County Court and the High Court of Justice. Civil cases, High Court. So as I discussed, that there are Queen Bench Division, Chancery Division, in family division. Queen bench division deals mainly with the contract or tort dispute. Okay. So I think this was a Fan's question. So basically, this is contract disputes. Okay, any let's say contract breach, contract breach. The chancery division deals with the law, trust, probate, copyright, company law, partnership law, revenue law, and insolvency cases. And by interestingly, we will be covering all these laws: partnership law, company law, not revenue law per se, but insolvency law definitely. Okay, see, the idea is not to memorize these things. The idea is to give you an idea. Okay, there's a civil division of courts, there is a criminal division of the courts. Okay, and we are right now learning ACCA, so that's why we are learning UK system. And here we will be learning about the how basically courts function. And once we will be discussing these things in companies act or partnership act or basically insolvency per se. So if any course needs to be taken, so we will basically need to check whether we need to go to the chancery division, or let's say if there's a contract dispute, so whether we need to go to the queen bench division. Okay, just like criminal cases, county courts or magistrate court are the first instances where basically the case is first registered. So county court for criminal cases and magistrate court for the criminal offenses. Hope this is clear. This is already we have discussed already, but let me just quickly discuss like doctrine of judicial precedents. If a precedent has been set, so what would be the further course of action? Okay, if a precedent has been done, some precedents are binding, basically they must be followed. Others are merely persuasive if material facts are not, if material facts are not same, are not same. Okay, the application of consistency is the basis of judicial precedent, which has the following rule. If we are applying a judicial precedent, so what we must see, a precedent must be based on proposition of law and not a fact, basically not a question of fact. So when we apply a precedent, so it's not that we are trying to prove the facts. Facts is in the precedent. When we are applying precedent, we are not saying about the facts. As I mentioned earlier, the material facts need to be same. What does it mean? Basically, let's say we are not establishing, let's say the lady example that I have given is basically got injured in the basically in the shopkeeper place. So here we are not establishing whether lady got injured or not. That is, we are accepting when we are applying a precedent now, we are accepting this within the court that the lady got injured. We are not disputing that. So when we are applying a precedent, we do not question the fact. Okay, that is acceptable to all the parties, that lady got actually injured and within the shopkeepers. So nobody in the basically law in the when we applying the precedents, so nobody is questioning the facts. It's just the proposition of law whether the injury in a shopkeeper place should be applied. Okay, this is the proposition of law. Let's say there are 2 to 3 precedents happened in the past, so which precedent is applicable to this case? This is something that we are discussing. We are not discussing the questioning of the facts. We are not basically questioning the facts, we are questioning the proposition of the law. Is it clear? When I say, let's say there are 2 to 3 cases, so which case will be applicable in this will depend on the material facts of the case. And when I say material facts of the case, that means I'm not questioning the facts of the case. I'm not saying no, I'm not injured, no, this person is falsely claiming. That is not we are discussing. We are discussing, let's say the facts are agreed by both parties. It's just that whether this will be applicable or not, this is the question. Clear? When I say proposition of law and not a fact. So when we apply a precedent, it's not like any precedent can be applied, whether or not material facts are matching. If material facts match, only then we apply the precedent. Okay, guys? Only one student has said yes. Is it not clear? Yes or no? Kushi says yes, Arya says yes. Okay. I have to push you sometimes. The fact of these cases being considered must be materially the same. Okay. Here we are checking whether we should apply the law, and here we are checking whether facts are same. Previous courts must have had the power to bind the code making the decision. Very important. So, see, understand, a court case can only be binding. This is something that when I learned during my practice. So when I was in my internship period, and we were discussing income tax act in India. We have income tax act, so we were discussing income tax act, and there was one case to be presented. So the case was to be gone to a high court. So I was researching, I was part of researching team. So what I did, I found a case which was helping us to win the case. Because when you are in court, so you try to code the previous precedents. This is how you try to favor your argument. So what I came up is with the material facts which were exactly matching our case. But the problem was that the case was going to the high court, and the finding that I had was for a tribunal court. Okay, basically a lower level court. So if there is a decision in a lower level court, that cannot be binding on this superior court, basically high court or supreme court. But if there had been a decision of supreme court, then that basically mandates for the high court to consider. Clear? The hierarchy. That's why we discuss this hierarchy, that not only that we can challenge the cases in the upper courts, but the decision of the upper courts basically become precedents for the lower courts. Clear? That if decision has been made by the supreme court, if supreme court makes any decision, then this becomes precedent for the court of appeal, crown court, high court, or basically county court. If decision has been made by high court, then this becomes precedent for the county court, but not for the court of appeal. Clear? So it depends on which hierarchy. So only previous court must have had the power to bind the court. In order for a precedent to be binding on the judge in later cases, the material facts of two cases, basically this is same thing. Their significant precedent will be persuasive rather than binding. Okay, this is just for your FII in case you are interested. Precedent can be overruled by a higher court, because we have already discussed this again. And this is just an information in 1966 House of Lords Supreme Court since 2009. Okay, now how do we interpret the law? How do we interpret the law? Very interesting. Has anyone ever read the law in bare text? Has anyone read the law in bare text? Do you want me to show you any bare act case? Nope, nope, nope. Okay, let me just quickly show you. Uh, just a second, huh? Just a second. I'm just stopping the screen share. Just opening the one basic income. Okay, so let me just share a screen for you. Is it visible, guys? Let me know. Is it visible? So if you see, this is a bare act. Bare act means basically how the act is originally created. Okay, so this is called bare act, and I have taken in Indian act as an example. So you can see this is an income tax act. This you can see this is an income tax act of India, formulated in 1961, and basically act of parliament. Okay, this is chapter number 1, and this is its first section. And if you see that this section basically tells that this act may be entitled to income tax act. Okay, this act basically will be called as income tax act, and this act basically extend to whole of India, save as otherwise provided in the act. Now when I say this save as otherwise provided in the act, it has a meaning to it, and this is called basically technical definition. Let me just read the second part. This is section 2 of the act. This is subsection A, or basically in whenever there is a definition, this is called clause. So here it's not, instead of subsection it's called clause. There's a reason, basically once you start reading the act, so you'll understand. So this is section 1 clause 1. Okay, Advanced tax means the advanced tax payable in accordance with the provision of the act. Agriculture means that any rent or revenue derived from land which is situated in India for agriculture purposes, and income derived from such land by agriculture, performance of cultivator. So if I, I start reading this, you would suddenly find that the language is very technical, and it is, given in a very structural order. And those, who for the first time they start reading the law, it's like, what somebody has written is not clear. Like for me, when I started reading the law, it was like, why they have made it such complicated things? Why they have not simply written, okay, do this, do that? Why they have, complicated things in this way? So the reason for this is that law must be interpreted correctly. Law has been given for the as a guidance to all, okay, covering all possible situations. And that's why there needs to be, correct interpretation of the law. And how this is done, so this is what we are going to cover here. You read the law, sir? No, 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 no. This is something that, when you are in part of a CA firm, I was part of a CA firm in India, which is basically, reading Income Tax Act, reading Companies Act in India. So I have done those things, and in those we used to interpret. Let's say if a Companies Act, has come and we need to, consider issuing share capital. So a case of that. So how do we, interpret that? What issue of share capital means? Like I remember Companies Act 1956 was replaced by Companies Act 2013 in India. India has the Companies Act in 2003. A latest act was enacted in 2013. So many changes were done. Okay, one was, related to depreciation, that there would be a depreciation schedule. If I talk about from finance point of view, there was a depreciation schedule. There would be a one-person company. There would be, changes related to companies filing processes. So all these were given in the act, and we need to, read these acts and understand them. So understanding act is not easy. Understanding requires, expertise. So it used to be what we used to do in my practice time. So you may get the opportunity to read that in case, you start reading Companies Act, Income Tax Act, or basically let's say any financial act, let's say excise duty, custom duty, any particular act you are into, let's say Partnership Act, if you get the chance. If not, then that's fine. But I want to basically make a point here is that reading law requires certain set of skills, and you need to have those skills because we are reading the corporate law. Okay, so though in anywhere there's no law mentioned, there's no act or any section is given, we'll be discussing the arbitral act, the how basically arbitral process goes on. So we'll be discussing their articles. But other than that, there's no as such law given in your book. We'll be discussing Companies Act, but in basically simple language, not in the bare act. Yeah, it's gibberish. It's gibberish. If you don't know how to read the law, then it's gibberish. Okay, Arya? Yeah, Kamal, that's very good point. That every word written is very important. Let me give you one example. That in India, income tax, income tax will be, paid by a person. Okay, by a person who basically has taxable income. I have just given this a very, I have given this in a very simple term, but what I'm trying to give you is just an example. Okay, if you read the exact, the charging section of the Income Tax Act, you would find it very difficult to understand. But I'm just giving you a very simple definition. In India, income tax would be paid by a person. Now, who is a person? Act defined person is an individual. Okay, an HUF, basically Hindu Undivided Family, a partnership, a company, a basically, society, cooperative society, okay, a government trust, okay. So can you see, just a word has been defined in the act, like who will be the person. Because if if company is asked to pay the tax, then they can simply say, okay, this is, income tax is only applicable on person, so I'm a company, I should not pay the tax. So in income tax, in order to avoid these situations, they have, given these, that like what is a person. And I'm just giving you an example. There would be many situations where, the act requires, let's say if I talk about corporate social responsibility. Corporate social responsibility is where that, if you are a big large company, so you would require to, contribute back. Let's say if you are a company, then in CSR, corporate social responsibility, you are required to contribute 2% of your profit to the society. Okay, let's say any societal act, let's say creating toilets, creating education, all this stuff, basically providing education and all this stuff. So CSR. Okay, now if you read the act, you need to first define which company is supposed to do. So act would define, okay, what companies would be participating in this CSR, whether all company or excluding some companies. Like act basically exclude one person company, act exclude small companies. Now what are these? We have to read the definition of small company and one person company. So do you understand that whatever is defined in the law, we need to interpret it correctly? Or let's say, let me give you just one or more example, just last example. Let's say we have GST system, the tax applicability system. How do we charge tax? Or in many countries, it's called VAT, value added tax. So let's say there would be, a case where, tax rate has been given as, say, let's say 12% or let's say 5% for a list of items. Okay, let's talk about, shirts, pants. Let me just give you an example: shirt, pants, or let's say, jackets and others. So if I write other in a list in an act, so what does this other mean? Can anyone tell me what does this other mean? Does this other mean pen, car, or does this other mean basically, anything related to clothing? Hello, am I talking to myself? When I say in act, let's say we will charge 5%. So I write shirts, pants, jackets, and other, and the rate will be 12%. So tell me, what does this other mean here? Should it mean pen, car, aeroplane, or should it mean, anything related to clothes? So you used your, your answer is correct, that it should be related to clothes only, right? That is the intention of the lawmaker. So you used your sense, you used your common sense. And this is basically just an example of interpreting the law. Clear? Law is very interesting, creating a law. It's a habit practice. You cannot, on one day, you have to understand that if you read the bare act, you have to give the, appreciate the gravity of the, the technical language, that this will not be easy to interpret, especially for a beginner. You need to have a background why law was created. You need to have a background like why, what this section says. Let me just give you, when since we are discussing, so let me just give you a couple of things to understand if you read an act. Okay, if you read an act now, understand that there would be sections or articles. Okay, articles, we in India use articles for constitutions. Okay, Constitution of India, or articles are used for treaties. Okay, national treaties among the countries that they decide in agreement among themselves. Okay, section is for, simple act which is applicable on any country. Let's say Income Tax Act, Companies Act, basically, Pedestrian Act. If you walk on the pedestrian, so there's a Pedestrian Act. Or, owning a Vehicles Act. So act is there. So it might have certain sections. Sections will have certain subsections, like section 1, subsection 1. And then if there is, a further part, so it's called clause or subclause. This is how, act is read: section 1, subsection 1, clause A, subclause 1. Or in case, section has definition or exemption for a particular case, so normally is section 2, clause A. This is, not very informative, but I'm just trying to give you example. So how the act will be given: in first act, it will always tell you about its applicability. like where act is applicable. Like in case we started with the income tax act, so it state that act is applicable to whole of India. Okay, so that means whatever is defined as per the India will be basically where this will be applicable. So this is the jurisdiction of this. Second, in section 2, mostly it gives the definition. And from section 3 onwards, basically acts tells about what will be the rest of the sections, who will be paying the tax, how it will be collecting the revenue, those who don't know pay the tax, what will be their fine and penalty, what would be the rate that will be paying, what would be the benefit to the people who are paying. Okay, so this will be given in the rest of the sections. Okay, any special rule and regulation they want to enact. And similarly, this is case for article. If you read the constitution and you read the article 1, so you would learn, okay, basically what is the India, definition of India, what is India, and what basically India is a sovereign state. Sovereign state means independent state. I hope we have established this much. So this is how act are given, act are read, and act are understood. And one more advice, in case you ever read a law, always try to get the background of the law. It's pointless to read the sections, it's pointless to read technical words unless you know why they are given in the first place. So it's always best to have a understanding of the law. Let's say if I just give an example of GST again, the indirect tax. So we know that GST is a act which is applicable for collecting taxes, okay, on consumer goods, or let's say it's an indirect tax act, indirect tax act. Okay, so those who don't know what is direct and indirect tax, so when you will be covering your text chapter, so you will basically understand. I cannot discuss this in detail, but just for the sake, it is collected by the shopkeepers or by sellers and then deposited to the government. Okay, so this act is basically for the purpose of consumer goods, or for the trading purposes, and then basically tax is charged there, and how it is basically enacted. So you need to know the background, and then you basically start reading the act. So much clear? This was just for your purpose, just basically we are reading the law, so we should know these things, not because it's part of your syllabus. Okay, okay guys, cool. Let's come back to the syllabus. We have to finish the syllabus as well. Okay, so far good now. Okay, okay. So, so common law. What is common law? How? Sorry. How do we interpret the common law? So see, one thing. Basically, there are certain rules. When we talk about common law, there are certain rules. One is called literal rule. One is called golden rule. One is called mischief rule, and then purposive rule. So we will be basically understanding these rules based on the case studies. Okay, that case has happened and what was the decision of the court. So let's start with the literal rule. Literal rule says that word must be given their ordinary dictionary meaning. That whatever is given in the dictionary, we should understand the word from their sense. Okay, ordinary dictionary, basically natural meaning. If I say natural meaning, if the procedure, even if the procedure is undesirable outcome. So let's discuss this. There was a Fisher versus Bell. So if two parties' name has been given, so that means that definitely it was a civil law, civil case, and not a criminal case. Okay, the court, not a criminal case, just in case you confuse, not a criminal case. Okay, fact was the court had to consider the meaning word of offer for sale. So what happened? That this shopkeeper actually were trying to sell the knives, and these were sharp knives which could be used for robbery and basically gang violence. So the at that time the government banned any type of sale of any arms, or basically any type of explosives, or any types of weapons. So this was banned in the country. So this shopkeeper actually tried to sell the knives, so with the price tag. So here the court actually the court case started, and this case was disputed on the definition of offer for sale. That what is offer for sale? Basically the shopkeeper said that I never made an offer for selling the goods, so I should not be part of this, I should not be part of this act. This was the contention. What was the decision? The court actually applied the literal rule. What is the literal rule? The court applied the literal fundamental principle of contract law in literal fashion. Basically, whatever the normal, if you read the law and basically whatever normal sense it make, so you basically apply that. Accepting that display of flick knives was an invitation and not offer for sale. It was the customer who made an offer to buy. In consequence, shopkeeper was not found to be acting illegally. So what has happened? Shopkeeper basically what have done in their shop, they have displayed the knives. They have displayed the knives. Okay, very bad timing. Okay, they have displayed this knife and with a price tagging. Okay, let's say $1. So this was just an invitation to treat. Let's say you can come in the shop and I would slice bread and butter for you. Okay, this was not considered a offer for sale as per the literal rule. So here the shopkeeper was basically not fined in case of illegal activity. It was the customer who approached the shopkeeper for buying the knives. So this was the offer made by the customer and not by the shopkeeper. So hence here shopkeeper was not found guilty for offering for selling any weapon. So this is how the literal meaning basically saved the shopkeeper. Very interesting, huh? That you can just using the words of the law, just interpreting them correctly, you can get your neck saved. And this is called loopholes. This is actually called loopholes. You misusing the law in your favor. And this is what law experts are very good at. Clear this literal rule? Anyone? Any doubt? This was basically Fisher versus Well. How this was not between state and how it was between Fisher and Well. The simple reason is that the one party, whoever was the buyer, actually claimed, actually tried to over smart and tried to claim that the shopkeeper was actually selling illegal items, so they are not bound to be paying them any amount. Got it, Afan? So actually, why it is not state versus the shopkeeper, because it was not at that time considered illegal, and it was the buyer who was not ready to pay, because basically they bought it and later they were not they were not ready to pay the amount, because they were thinking, okay, this person is selling any illegal item, so I will not be eligible to pay them. I will not be bound to pay them, because you are not supposed to pay any for any illegal item. So this is why this case was disputed in civil court. Okay. Now, what was Kamal's question? Isn't it how tender contracts was? So, Kamal, good question. Like how basically it's not offer for sale, it's invitation. We will cover, like I'll just tell you one case. One person has given an auction. They announced in auction that they will be selling this furniture. So one person, like let's say Mr. Amar. So Mr. Amar has heard that Mr. Sham would be, conducting an auction. So Mr. Amar thought that he would be coming at the place and buying some furniture. So he, booked his flight and, basically gone to the place. And there he found that the auction has already been done 2 days before. So Mr. Amar filed the case against Mr. Sham that he has, spent money and he could have bought this furniture, but he have already concluded the auction. So he fought he basically sued Mr. Sham for this. But it was held that announcing an auction, announcing or basically of inviting some tenders or prizes does not result in offer for sale. It was an invitation for sale. It was not an offer for sale. This is two different things. When you invite, so it doesn't constitute, it doesn't constitute as an offer. Clear, Kamal? So this is how, technical, yeah, you remember. These are some famous cases, so that's why I'm, telling you, so that it helps you understand. So these are basic fundamentals of, law. Clear na? Okay, golden rule. Let's little bit speed up because rest is very simple. Golden rule. Where literal rule gives more than one meaning or provides an absurd result, the golden rule is used to ensure that preference is given to a meaning that does not result in provision being an absurdity. Okay, what it says, that if we, take the literal rule, so we should not, it should not make law absurd. So what does it mean? A conviction was challenged on the basis of what appeared to be miswording in the official secret act. Okay, this is conviction. So conviction, Adler versus George. Convicted is for the crime. Conviction always happens for the crime. I'm not sure why is this Adler versus George. Interesting. It shouldn't be Adler versus George. Not sure what happened here. Because conviction is for the crime. And if this is a crime, it should be state versus the party. Okay. The act made it an offense to obstruct a member of the armed force. So definitely it's a crime. Okay. In the vicinity of particular location. Okay, interesting. But not actually in those locations. The defendant was actually inside an Air Force base at that time of the incident, which he claimed was beyond the literal scope of the act. So what it's saying basically, let's say some person has, struck one person, okay, has, has this bat and, had they have struck the other person. Very strange act, armed case. Okay, they are in a particular vicinity, let's say air base. Now this person has struck this person. Now the case is the act says that if it is an offense to obstruct a member of the armed force in the vicinity of particular location. But this person who has hit is claiming that they are right now in the airbase and not in a vicinity, not in a particular location. Okay. Basically, this he's playing with this word off and basically in. So he has said that we are not of this vicinity, we are in this vicinity. This is how, he's trying to play with the law word. So here the court basically held that in the vicinity of a prohibit place in the official secret act were held to cover the acts of defendant which took place within the prohibited places. Very strange. Basically, I'm not sure like why this was even discussed. If the person has struck, so this should be definitely offense punishable, but somehow if it is a prohibited area, so it's out of the scope of the act. So again, so it's like how this person played. If those who didn't get it, let's talk about India. If a person has struck another person within the jurisdiction of India or outside India, let's say this person is of Indian jurisdiction, and suddenly let's say they go to UK, and suddenly this person got attacked here in the UK. So the person who's here in the UK is saying that no case should be filed in India because this case is out of the scope of India. This is what basically happening here. So they are basically playing in the uh, this is where they are playing. Okay, so that is basically the court was trying to apply the golden rule, that when we say the vicinity, it does not mean that it exclude this place. It does not mean to exclude this place. So just going by the literal definition doesn't serve the purpose, so they applied the golden rule here. Okay. Sabaj says, what is the difference between invitation and offer for sale? So see, Sabaj, as I given you example, let's say you have a pen and I am asking you to please sell me this pen. Or let's say I have a laptop and I am asking you to whether you want to buy this laptop. So it would be directly constitute as a offer for sale. But let's say because it is directly to you and I have given the price to you and I have given my laptop as a as an auction that I will be selling it to you, so it will be directly constituting an offer for sale. Okay, when you accept this offer, then it basically creates a contract. But let's say if I have shown in this class, if I just bring my laptop and basically shows to all of you and says whoever is ready to buy, I will be I will be selling them. So this is an invitation to buy. Now any of you who agrees to buy this, who any of you who agrees to buy this will be making their offer. Now whatever offer you make, then I will be accepting. So in this case, Shabazz, the difference is that in an auction or in an invitation, the offer has not yet made, the offer is yet to make. Okay, but when I directly tell you individually and tell you, okay, you can you want do you want to buy, so I'm basically making you an offer for sale. The good. Okay. Sorry, huh? So this is what basically interpreting the law does. Is it clear? And this, there's a famous case, hang till death. Has anyone heard about this? Just to give you another context, this has happened that that a sharp lawyer, actually a person was convicted, the defendant was found guilty, and it was present, and it was supposed to be hanged. Okay, so when we say hang in the law, it means that the person should be killed. The person should be killed. That is the understanding of hanging, hanging them by neck. So that means that person should be killed. So what happened, this is I'm not sure like this has actually happened, but this is what I remember, that the guilty was hanged, but the moment they were about to be executed, the moment the person was about to pull the lever, their lawyer actually stopped the hanging process. The judge asked what happened. The lawyer said, your sentence has been completed. You have hanged the person, but you never said that they are supposed to be dying. And as per the act, act, a person who has been hanged once cannot be hanged twice. This is specifically given in the act. If a person has been hanged once, so they cannot be hanged twice. So if one person gets hanged for one crime, so if they get saved, so they will not be able to get hanged next time. So if some person, that's why you can see that sometimes court judges, basically what they do is they hang the people till death. Till death. This is this further substantiation of the word, because of a practical issue. So whenever you read these technical words, actually something has happened in the past, and that's why some technical words have been brought forward. Clear? No, I just want to make you understand the importance of interpreting the law, and how lawmakers, how the lawmakers, the executives, the judiciary, the lawyers, how they try to use the law. Businessman uses the law as a ACCA qualified. What you will do, you will be not only accountant, you will not only do the accounting, you will be participating in the decision makings. There can be possibility, you may what is a good financial expert if they cannot make the decisions? What is of a good of a financial expert if they can't make the decisions? So you should be able to make decisions, and understanding these things now will help you making decisions. Okay, what is contract? um, what is law? Interpreting them really helps. And this is why this is called knowledge is power. This is actually true in these cases. Okay, mischief rule. Coming back here, I have to stop myself. No, I'm discussing too many things. Used to interpret a statute in a way which provides a remedy for mischief of the statute enacted to prevent. Okay, so what is the purpose is that, let's say a law is basically created, this rule is to interpret a law in a way that provides a remedy to the mischief is, let's say we want to stop something from happening, so that is basically mischief. So we want to a remedy for a mischief. Let's say somebody is stealing, so mischief is not steal, remedy is not stealing. Okay, So if it's a remedy for a mischief, so we try to provide the law, we try to provide the remedy. So let's say if we have created a traffic rule is created for the mischief of breaking the red lights, breaking the traffic rules, basically the red light, green signals, okay, not following the law. So this is the mischief. So we have introduced the traffic rule as a remedy. Now why this mischief rule is applied, let's understand. There was this contagious disease act 1869, obviously of UK, provided that any ship carrying animal should contain them in pens. Okay, the defendant, basically the case was filed by between any of these persons. So let's say defendant neglected his duty and some claimant ship were washed overboard. So there was this ship going, okay, so the ship was going, and here there were certain cattle ships. Okay, now as per the act, as per the animal disease act, it was supposed to be contain them, it was supposed to pack them. So the act purpose was to prevent any type of disease. Now what happened in a stormy sea, what happened that some of the ships actually got lost in the sea, lost in the sea. Some of the ship is basically, let's say the ship is sinking here, crying. So it's actually lost in the sea. So actually the person whose ship was that actually filed a case against the ship company. So it was held. This act purpose was to prevent the contagious disease and not to guard against any danger to the property. So if the ship have been basically lost in the sea, so that is not what act covers. The act basically covers the mischief it was supposed to cover. So here if the case has been filed under the contagious disease act, so you cannot say that sheep got lost, that's the problem of the owner. No, if there was a case of negligence on the way this compartment was built, that that disease could be spread, then only the case was possible to file against that person. Otherwise, just because the ship got broken and then the sheep got lost, the animals got lost, so you cannot file case against them, because the act purpose is to prevent the mischief and not for property damage. Clear? Clear, everyone? Yes, okay. Purpose purposive law rule, basically the purposive rule is to what was the purpose of the law. It's similar to mischief rule, like what was the purpose of rule. I think in your BPP book this mischief is same. Let me just quickly check. In your book this mischief is actually same. Yep. So they basically the purposive rule is basically similar to mischief rule. What was the purpose that law was enacted? What was the purpose? Basically this mischief rule is given in your Kaplan, and this purposive rule is given in your BPP. So what was the law? It was enacted. So both have explained this situation, it was enacted. So both have explained the situation with different case. So let's understand the case instead of uh, uh, the rule. The purpose of the act was to provide the safe storage of film wherever it might be stored on the premise. What was stored on the premise? Okay. The claimant argued that premise did not include a cave, and so the act had no application to this case. So some person, there was a film basically the rollings of the film, and this person, stored the film in a cave. So the person who have stored the films in a cave, so because of that, the films actually got destroyed. So they actually held that cave was not basically is not a premise, so they should not be held guilty. But as per the purposive rule, the intention of the lawmaker when creating the safety for the damage of the property, they basically said, okay, no, it was to protect the safety of a person working in all places where film was stored. Okay, and this does not exclude this cave. So again, this is similar to mischief rule, that what was the act basically, created in the original place. Okay. Now, from now onwards, if you read this word, can anyone, read this one? Anyone who wants to, unmute themselves and want to read this? Or let's say this expressio. This should not be here. This is basically interpretation, separate. Hmm. So many of the laws are basically, yeah, sure, sure, yeah, sure. Let me just unmute you. Yeah, please go ahead, Arya.
It's pronounced as usdom.
Used them. Yeah, right. Right, Arya. Actually, basically, it's French language. Those who don't know, this is a French language, and many of the laws are basically driven from the French. So that's why, next is expressio, unius, exclusio, alterius. French language is a very good language. I know a little bit of things, but not detail. But yeah, French is a very good language. It's a very, very soft language, that is per se. Okay. Eusdom generis. What does it mean? It means general weeds mean the same kind of thing as the specifics they follow. Like I have given you the close example. I've already given you the close example. So this is basically a similar thing. So what was the fact? Section 1 of Betting Act 1853 prohibited betting in house, office, room, or other places. So the issue was whether a ring at a race course was in other place for the purpose of this act. Okay, so we have a race course. So when we talk about betting, so betting is prohibited within the house, office, room, or other places. So whether a race course should be part of this other places or not. So the basically Lord or the court decided that EU's drum generis rule was applied in this specific word, such as room and offices that preceded the general phrase or other places created a class of indoor places, not outdoor. Okay. So if you read the series house, office, rooms, so you can see these are some premises, okay, which are talking about inside thing. And when we talk about a race course, this is a outdoor places. But if instead of eusdom generis, eusdom generis, had we applied the purposive rule, do you think that this should have been held? If we talk about betting act, so don't you think that the purpose was to prohibit the betting? So if we had applied the purposive law, according to me, then the betting should have been banned, because the purpose of the act was to ban the betting. But here we have applied the eusdom generis. So the court actually applied the eusdom generis. So here the ring, the race course where there is a ring and people sit there and basically bet in the open area. So there basically it was allowed based on this technicality of other place. Clear? Now you may ask why eusdom generis were applied, why not the purposive law. See, that depends on the situation. Let's say if the case was fought at the high court level, so high court actually interpreted the word according to the law, basically applying the wisdom generis. But if you think that if this case actually goes to the Supreme Court, so if Supreme Court makes such decision, they will not only follow what would be the meaning of these other places, but they would also see what is the impact of the law on the society. Okay, so Supreme Court does not only take into account what is the interpretation of law, but what was the intention of the law, as well as what the impact it would have on the society. So Supreme Court decisions create the precedence on overall society. So that's why it becomes imperative that whatever decision Supreme Court takes, it also take into consideration the immediate or long term impact on the society. So in my personal opinion, this is only my personal opinion, not basically related to your study. If the Supreme Court would look at this situation. They would try to see the impact on the society, whether betting would be good for the society, how many people are betting in the society, and what is the whether it's creating good economic opportunities or it's destroying the economy. Based on that, it would either apply wisdom generis or purposive law. So do you understand that there are different ways of interpreting the same law? There are different ways of interpreting the same law. How court decides would depend on the level of the court, and would depend on the impact the decision would have. Okay, so that's why it's always unpredictable, like what kind of decision would come. See, that's what I was trying to explain, Arya, that court could use eusdem generis or court could use the purposive law, depending upon the level of the court, or basically the impact it has on the society. In case of high court, in case of court of appeal, this is basically to a specific state or to a specific region. So that's why they try to apply the law based on the how law has been created. But when we talk about the Supreme Court also considers the impact that any particular act has on the society. So if you ask me personally, had this case been in the Supreme Court, definitely this would have been banned. If and only if this betting has the overall adverse impact on the society. But in many countries, betting is actually flourishing and actually helps economy run, because many tourists come in that economy. So may be possible that Supreme Court in those jurisdiction may not ban it, because Supreme Court decision actually sets precedents. That is the problem. Clear? So you can see that different rules may be applied by the court in a different situation. And that's why the lawyers, the people who have received the court decision, they go for the upper court in the hope that this court might interpret the situation differently. Please understand why I'm discussing this. That if courts, if you go to a court, okay, and the court set a decision which is not in your favor, so you go to next court for the interpretation purposes. In high court or in Supreme Court, we go for the interpretation purposes. Unless court has done some negligence, most of the time we go for the interpretation, not for the fact of checking. We do not go there for fact checking. Fact checking is already been done, unless we claim that there has been some negligence. Otherwise, we only go for the Supreme Court or High Court only for interpretation. We do not check the fact there. Clear, guys? Everyone, was it clear? Okay. These are the presumptions. I'm not sure why these are doing what these are doing here. This should have been, once we were reading the law, common law, it should have been read there. These are, before reading common law, before reading common law. Okay, like how law will not bind the crown. Crown basically means the monarch system in the UK. Statute cannot conflict with the international law. That we will discuss later. Like if there is an international law and there is we have a law made in country, so it should not conflict with the international law. An act therefore should be interpreted as giving effect to the international obligation. So what it means, let's say national law says something, and then there is international law. Okay, so in this case, national law should be read in such a way that it conforms with the international law. Okay, and a very good example with the Amazon versus the future retail, or what I say is Reliance. This has happened like 2020 or 2021. It's a very good case, but I'm just waiting for chapter number 2. A statute does not have any retrospective effect. Okay, what does it mean, retrospective effect? Let's say if an act, let's say we had a Companies Act 1956 and suddenly we have Companies Act 2013. So if a law has been made, so retrospect actually means that it should not go back to 1956. Let's say if any changes have been made in the act from 2015, so these changes should be basically from 2015 onwards. It should not go back to let's say 2013 act, and any decisions till 2013 should be changed. But I will tell you, a good example here. I'm not sure, you guys are finance students, so you should know these news is like Vodafone versus Government of India. This was a historical case. Okay, this was a Vodafone versus income tax. This is a very historical case for income tax, where just one retrospective word actually tarnish the Indian judiciary system image in the international level. This was actually very sad that this Vodafone versus Government of India case actually changed many things, because it was in around 2012, and people got not a good impression of Indian country judicial system. What happened, that Vodafone actually won the case in Supreme Court. Vodafone actually won the case in Supreme Court that they were not supposed to pay 20k crores, 20k crores of tax. Okay, because they were on merit. Vodafone was not supposed to pay the tax, so they won the case on the Supreme Court. But that time of finance minister, Mr. P. Chidambaram of India, he was he decided that he would collect the tax. So he made the act in retrospective effect. What does it mean? That whatever law was prevailing in before 2012, as per that, Vodafone won. But Mr. P. Chidambaram changed the act from the 1962, because in India, Income Tax Act is from 1961, 1962. So he changed the act from 1962. And this is called retrospective effect. And because of that, Vodafone had to pay this 20,000 crore. Though it favored the Indian government, but it actually damaged the Indian reputation. So this is basically retrospective effect means. Clear? And we will discuss why this retrospective effect has certain consequences on international level. And countries try to make laws that are prospective effect, not retrospective effect, because that creates a cohesive environment for the businesses, because they are not sure what they will do. Okay, these are the presumptions. Please read whenever you get the time. This should be read before reading the common law. I'm not sure, like this might be mistake that it is here. Now, expresso unius excluso alterius. This is basically French. What does it mean? When a statute seeks to establish a list of what is covered by its provision, then anything not expressly included in the list specifically excluded. What it means, that this is an exclusion clause. Exclusion clause. Let's say if a law states that um, person. Let's say, yeah, definition of person. In income tax, we were discussing the definition of what is person. So if the person definition has included individual, company, and any basically cooperative society, so this definition, if we talk about, let's say tomorrow alien comes on earth, so do they need to pay tax? This might sound funny to you, but think about it. If a person alien comes to on the planet earth tomorrow, so by the definition of person, by the definition of person, if we apply this rule, so if we see this rule, the this this basically is a kind of an exclusion definition, where this has given a list of people, and if they have given a list, so any person other than this list should not be part of it, and that is called exclusion. If law has given basically a list, if law has given a list, we are about to start civil law, which is very small. So if law has given a list and they have not used the word inclusive, including or inclusive, so we should treat this list as exhaustive. We should treat this list as exhaustive, and then anything not mentioned in this list will be excluded. Okay. If a list starts with including, then it's an inclusive list. If a list normally states things, and does not use this word inclusive, then it's an exhaustive list. And in this case, anything not mentioned in this list will be excluded. Okay. Let's say what arms you can possess. What arms you can possess. Let's say if you have a license gun, if you have a license gun, okay, license. Let's say home kitchen knives, okay. Let's say these two things are mentioned in the law. So tomorrow you cannot say that okay, I own a bomb, I own a bomb, and this is part of the arms list. Because in law specifically they have mentioned only these two items, and they have nowhere mentioned any other explosives. So if this is the case, then this is basically becomes exclusive list. Okay, is this clear? Though example is weird, but I hope you get my point. Clear, everyone? The expressio unius exclusio altres, meaning that anything that is given as a list should anything other than that list should be excluded. Clear, everyone? All clear? Any doubt? Okay, let's uh okay. I'm just thinking whether should I defer civil law for tomorrow. Okay, let's just cover them in detail, brief, and I'll just give you for reading, and let's see whether you have any doubt. Okay. Civil law is a law historically developed from Roman law based on codes of written law. So anything that is codified or basically as written will be part of civil law system. Okay. Why the civil law system is different from the common law? The purpose is that we have created a constitution. We have first created the act. They are people who run those acts, and then basically we try to interpret what those acts means. Whereas in the common law, what happens, that people are free to do what they want to do, but if there is a dispute between two people, then they go to court and basically settle that dispute. Okay. Here in the civil law, the court tries to act as an investigator, whatever try to interpret the law, whatever has been given by the legislature. Okay. Here the purpose is to write a codified law and then interpret it. Whereas in common law, what we were doing, we were seeing the cases, okay, whatever case or whatever dispute was happening in the case, and based on that we were creating precedents. Okay, this is the difference between the civil law and the common law. So it is written. Law is contained in codes which are drafted as general principle which should answer any situation. Derived from any above, question of law should be decided predictably in the context of courts. Judges only have limited power of interpretation. Source of law is basically country's constitution, European Union. We'll discuss European Union later on. Okay, in chapter number 2. Statute, which means codified as noted above. I mean, I then given administrative regulation and practices. What is the role of judges here in case of civil law? The distinction between those who draft the law, basically the legislature, and those who apply it tends to be greater in civil law system than case of common law system, because in common law whatever judges basically decide for the cases basically sets the precedent. And those who ask, like in India what kind of system we follow, we normally follow civil law, but we have also embedded, sorry, the common law. We have also embedded common law. How? Because whatever Supreme Court decides for a case, in case of interpretation, okay, that becomes a final wording. Okay. So Supreme Court has said, many judgmental decisions, basically very landmarking decisions, and that have been, set a precedent for the further cases. Like I have told you, like I used to, search for the law, like what could be the case law, and which basically I can, refer for, any particular income tax case. So Supreme Court has given many, basically, kind of landmark judgments that, serve as a precedent. So in India, we normally follow civil law, which has, codified constitutions and all that, but we also have embedded the common law, and this is a common practice. It's like a hybrid system, but more lean towards the civil law system. Judges apply the law, just creates a precedent, like I said, which must be followed by the other judges, but this is mainly for the interpretation. Okay, it's not, basically just basically uh, what I was about to say. Basically, yeah. So not basically creating the law out of the judgment. It's basically interpretation of the law that has been there. Law is there basically, uh, what speed of vehicle you will be driving. Okay, now what covers in the under the vehicle, that can be another question. If law is not clear what is the definition of vehicle, so their Supreme Court comes and basically can clarify for that. Okay, in case of a common law, two people fighting over that this person has, struck me with their vehicle, and this was the over limit, so they would basically create a law out of it. I hope the difference between the two systems is clear. Okay, law is basically very comprehensive, basically containing wider range of things, not only a couple of, one particular situation. And drive from, question of law should be decided predictably. In context of court, judges only have limited power of interpretation. So I hope the basic difference between the civil law and the common law is clear. Okay. Yep. Okay. So this part, this part, just try to read it once. Try to read as once. Like I would try to, understand you myself. But let's keep it then for the next class. Try to, read it for yourself for once, and then basically tell me whether you understand it or not. Though I know this seems little, very over intimidating, but don't worry. This is just French, and they have, explained here. Okay, try to read it once for yourself at home, and then try to let me know whether you understand it. Okay, this is the distinction also for your homework. Now, Sharia law, the last piece of this chapter. Uh, Anyone who can help me understand Sharia law? Let's see. Very good. Further, like further clarification, like why we have a Sharia law, why there is a Sharia law. Anyone who has any knowledge, I'll just understand, but I'll just tell you, but I just want to have an understanding whether you have any prior knowledge. For some it would be familiar, for some it would not. So I'll help you, but let's try to communicate with each other. Sharia law, guys. Ha, Kamal, Arya, you are correct. This is what we are I've been telling, like law based on basically law of Islam. Basically, Islam religion, we know there's a Hindu religion, there's Islam religion, there's a Christianity religion. So this law specifically caters for the religion of Islam. Okay, see, those who don't know, let me tell you. In the finance, uh, the banking system for the there's a Islamic law for financing. Okay, like how finance works. In normal banking, we have interest concept. Like we give loan somebody, and then we charge the interest on that loan. But in the Islam, there is no concept of interest. You cannot charge interest, and that basically makes the banking system very uh, you know uh, very different dynamics. It gives different dynamics to the business. There are proper banks that provide loan facility from which are based on Islamic concept, and they provide loan for the purpose of welfare of the society. Now businesses, because there's no interest cost, they see the opportunity there. Okay, This is something riba, and which we will learn. Like this is not basically very detailed given here, but like we have been given about the understanding of the Sharia law, like what is Sharia law, how Sharia law was made, and basically what are the components of it, and that we will understand. But what I want you to understand from this is that why this has been given in your syllabus, that you need to understand that the financial system has many aspects, and Islam based finance is one of the key components, especially if you deal with the Arab nations, the UAE and the other Arab nations. So you would understand that finance is one of the significant component coming from the Arab nations. And as a professional accountant, you need to know what kind of source of funds will be available to you. Equity capital, debentures, loans from banks, you have heard. But whether you can consider the option of financing from the Arab nations, that is also a very good business opportunity. So for that purpose, we need to understand what Sharia law is, what basically their component is, and then basically what would be the concept. Though in this syllabus, I think in the later chapter there would be some discussion, but first we have to understand the Sharia law. So far clear? So far everyone clear? That if I remember now from my study days, I think I have read the Sharia law from in the AFM, the financial management subject, and I think in the financial reporting or SBR. Anyone who can confirm me that anyone who has given FR paper and basically they have read the Sharia law for the finance? FM. So it is in the FM, right, Kamal? Ah, yep. So maybe you can help me better. Okay. So Sharia law, basically law based on religion of Islam. Okay, countries that are currently following is Pakistan, Iran, which have adopted Sharia. No, and there are countries that have either followed the Sharia law completely. Okay, that whatever Quran says, Quran or basically the holy book of the Islam, whatever that says will be the law of the country. Or some have coexisted with this. Some have coexisted with this, like they have parliament, they have a parliament, as well as they have basically law based on Quran. Okay, so these are two systems that are coming together. So depend on the country to country, they either adopt the Sharia or they basically coexist with Sharia. Okay, depend on the country. This is basically similar to the colonial system with the church. Has anyone heard about it? Like the British Empire, during the British Empire, what used to happen is that they have the colonial system. Like they used to go and set up their colonies in different countries, and church used to be a significant influencer in policy making, decision making, right? So this is basically the similar case. Okay, so let's study this. So the main principle of Sharia law is that main principle of Sharia law is that Sharia law is law given by Allah, basically God. Okay, is the divine way of ordinance for the mankind. Like basically, how would you live your life will be basically there is a direct revelation by the God themselves, and this is basically what Sharia is considered of. Okay, source of Sharia is basically there are two primary source. One is Quran, Sunnah, and secondary basically these five school of thoughts. Basically, these are five scholars on whose name these school of thoughts have been developed. Okay, so first is Quran. Quran is basically Allah's divine revelation to Prophet Muhammad. Okay, so the divine entity Prophet Muhammad, they have received the basically revelation directly from the God themselves, and this was basically formulated as Quran. And this Sunnah, this is basically also known as beaten track. In other words, what has come what has come to be acceptable course to be acceptable course of conduct derived from the saying of Prophet Muhammad, please, which is also known as hadith. Please understand, Quran is basically divine revelation of God by the Prophet to Prophet Muhammad, and Sunnah is basically the saying of Prophet Muhammad to their subordinates. Okay, so these are the two sources, Quran and Sunnah. Now, the secondary sources for the Sharia law is basically which are also known as madhab. Okay, these madhab are known as basically once the immediate death of the Prophet Muhammad, these school of thoughts were basically based on the writing and thoughts of major historical jurists. Okay, so these are the scholars, and these scholars are basically categorized into five categories: Shia, Hanafi, Malaki, Hanabali, and Shafi. Okay, and these have been categorized into two categories. One is this, and one is this. So this is basically called Sunni, and this is called basically Shia. And I'm not sure like how many of you know this. Based on these two categories, like these are the two categories of set of practices, and based on these two practices, basically there is a category of Muslim community, like this is called Shia Muslims, and this is called Sunni Muslims. Now, what I understand, I may be incorrect, but what I have read is that this is basically somewhat 70 to 80% of the Muslims, and this is what somewhat 10 to 20% of the Muslims. That this is the practice mostly followed in Iraq, if I'm not correct. If I'm not Iraq or Iran, I think. Not sure. Like Iraq or Iran, I'm not completely sure. And this is basically the rest of the world. Okay. These are the school of thoughts: Sunni Muslims, Shia Muslims. Shia basically based on the scholar of this school of thought, and this Hanafi, Maliki, Hanabali, and Shafi'i basically creates the Sunni. Okay, and these are called madhabs. Now, further. Yeah, I was correct. Iraq and parts of the Iran follows the Shia schools, basically Shia Muslims. Majority of the Muslim world follow the four school, which together called the Sunni Muslims. Okay, many Muslim countries, example Iran and Pakistan, have a written constitution. Like I said, they can have a written constitution, but also which also upholds the Sharia law. So the constitution has been written in such a way that upholds, that basically accepts the Sharia law. Okay. Now, role of judges. Like we have judges in case of our normal court system. Okay, just 5 more minutes, guys. 5 more minutes, will it be okay? Actually, I wanted to practice the questions as well, but I think we have exceeded. Just 5 more minutes. Okay, na? Any? I hope because students are already low. Please don't leave. Okay. Role of judges. Okay. Judges in Sharia law are generally clerics. Okay. So like we have a common law, civil law, we have a judges who basically, interpret the law. But please understand, because Sharia is a divine revelation of God, Allah themselves. So that's why there is a limitation of, interpretation. Like the clerics, basically the judges, also known as imam, basically they have a limited power interpreting the law. Okay, and this basically creates further discussion about the taqlid and ijtihad. So we'll discuss them. So judges in Sharia law are generally clerics, also known as imam, given the religious nature of law. Although some countries also have secular judges. Why there is a secular judges? Because some country have the written constitution. Judges are required to apply the law. Okay, they are supposed to execute the law, just like in executive. If there is a law, so judges will be reading it from the Quran, from the their Bible, and then basically they would be passing on the judgment based on whatever has been given in the holy book. Okay, they are limited powers of interpretation, given that law was ordained by the Allah. Okay, interpretation of the law. If clear guidance is not available in the Quran, or Quran does not give guidance on specific matter, a cleric may refer to Sunnah to confirm, explain, clarify the law. If nothing is clear or ambiguous in the Quran, so then we would basically come back to Sunnah. Okay, like whatever has been written or basically interpreted by the subordinates of Prophet Muhammad. Okay, within the Sunnah, Adhid are classified according to their reliability. So what were the Adhits? If you remember, these. these are basically whatever the subordinates of the Prophet Muhammad have written, and they have been basically considered as per the reliability. So how much they are reliable, basically, because they were after Muhammad Prophet were passed away, so after that they have been interpreted. So that's why they have been certain considered are virtually guaranteed, and certain are basically basically question on their reliability. Like Muwatir are considered to be virtually reliable, Mashtur are less certain, Ahads are little certainty about their reliability. Okay, so Muwatir are basically considered to be basically virtually guaranteed. Okay, there is a controversy in the Muslim world about the further interpretation of the law, because some people say, okay, we are not supposed to interpret the law. The way it has been, developed is sufficient. Whereas some people, give the argument, no, we should, basically interpret it more, because as the time progress, we should evolve about, and we should evolve and we should learn more about it. Okay, as per the time, we should, interpret the situation. Okay, not from the word. And this is basically creates two school of thoughts, which is one is taqlid, which is the theory that interpretation is sufficient and does not require further interpretation, and second is ijtihad, sorry, ijtihad. Let me know if I'm not very good, so please let me know if I need to be correctly pronouncing them. Okay, so as per the ijtihad school of thought, that there should be sufficient interpretation. Okay, that we should interpret the interpret this law. But who would interpret it? That has been clearly defined, like who can basically study the Quran and who can basically further interpret it. So the principle is basically must be carried out by a suitably qualified person known as mutahid, okay, who has studied the Quran and tradition of the Prophet Muhammad, understand the principle of ijma, understand the condition of qiyas, and just reliable, trustworthy, and good practicing Muslims. Okay, so these are the principle given by the ijtihad, that if you want to interpret the law, so you have to have these qualities. Okay, like if we know that these are the scholars, so these scholars used to have these qualities. Okay, so similarly, if a person who wants to follow the ijtihad school of thought, so they have to have these certain criterias. Only then they will be able to interpret the law. Okay, and there are prohibitions, like you are not supposed to interpret certain matter, like whether Allah exists. So this has to be accepted, and this cannot be further interpreted, this cannot be further questioned. Okay, now there are further categories like ijma, qiyas, or ijtan. Okay, I think I'm just running over the time. Okay, so these are the, please read once and let me know if you don't get any clarity. Okay, we'll discuss them in the next class. Why we have to discuss? Because 1 mark or 2 mark question can come, and you must know like what is ijma, what is qiyas, what is ijtihad, what is taqlid, or basically let's say sunnah, or basically muftari. These words would be starting you might struggle, but please trust me, with time you might basically will become comfortable, and you can score good marks out of this. Definitely some knowledge based question would come out of it, so you should not miss on those marks. Okay, so with this, our chapter number 1 is almost finished, so let me know, tomorrow we'll have a discussion. Though I wanted to do some questions, but I think I have already exceeded my time, so let's not exploit you guys. Sure, Kamal, go ahead. Okay, so far no questions now. Okay, thanks. Okay, please, those who have questions, please ask me. And otherwise, we have covered the syllabus. Well, we have covered the chapter number 1. Syllabus is too big to cover. Good night, Shabazz. Okay, okay. But the batch is just started in the December. Yeah, sure. You can see, Kamal. Actually, students also ask me queries, but Problem is I also have Monday to Friday office, and it becomes difficult for me to apply, reply in the morning time. I'll try to see the queries and reply them by evening, but many students are not comfortable with this approach. But I cannot help with this. So please understand that if you send a question, so might be that I might be replying by the end of the day or maybe by next day. Okay, but I'll definitely reply. It's not, I don't like any question left for the students. Okay, 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 Kamal. No worries. Okay, so you can ask me the question if you have any. Okay, so I think we are good, guys. Okay, with this, we have wrapped up the chapter number one. I hope that was fine. I hope my speed is okay, right? So please let me know in case you have any feedback, you have any suggestions to improve. Let me know. Okay, and we'll tomorrow we'll start chapter number two. Hopefully, chapter number three as well. Okay, guys. So good night, nighty night. Bye bye. Bye bye. Thank you. Bye bye. Bye, Arya.